speak to whether you're right or left or your judicial philosophy or qualifications. They wrote an impassioned letter for the sake of our democracy. They publicly issued a statement asking that your nomination, that you withdraw from this nomination process and have it be halted until after the November election. This is not normal. And again, the overwhelming majority of Americans want to wait, but my colleagues here are not.
That nervous laughter makes it sound like you're full of shit and you know it.
Not listening. And so I'm going to ask you some questions that if you had told me 5 years ago, that would be questions asked at a Supreme Court nomination hearing, I would have thought they wouldn't be possible. But unfortunately, I think they're necessary.
The impression I get in this context anyway.
And I hope that you'll give me direct answers. The first one, you've already spoken towards issues of racism and how you deplore it. But I want to just ask you very simply, and I imagine you'll give me a very short, resolute answer. But you condemn white supremacy, correct?
Yes.
Thank you. I'm glad to see that you said that. I wish our president would say that so resolutely and unequivocally as well. But we are at a time that Americans are literally fearful because their president cannot do that in the
Maybe he does, but a vote is a vote.
I'm sorry that that question had to even be asked at this time. Here's another one. Do you believe that every president should make a commitment unequivocally and resolutely to the peaceful transfer of power?
Well, Senator, that seems to me to be pulling me in a little bit into this question of whether the president has said that he would not peacefully leave office. And so to the extent that this is a political controversy right now, as a judge, I want to stay out of it, and I don't want to express a view on.
So, Judge, I appreciate what you've said about respecting our founding fathers, about the originalism. It's remarkable that we're at a place right now that this is becoming a question and a topic, but I'm asking you, in light of our founding fathers, in light of our traditions, in light that everyone who serves in that office has sworn an oath.
That's it. Twist shit against. Shut up.
And protect and defend the Constitution of the United States.
I'd be saying, move on to the next question.
President commit themselves, like our founding fathers, I think, have a clear intention, like the grace that George Washington showed to the peaceful transfer of power. Is that something that presidents should be able to do?
Well, one of the beauties of America from the beginning of the Republic is that we have had peaceful transfers of power, and that disappointed voters have accepted the new leaders that come into office. And that's not true in every country. And I think it is part of the genius of our Constitution and the good faith and goodwill of the American people that we haven't had.
I don't think the Constitution says anything about peaceful transfer of power, so.
Where those issues have been present.
Thank you, Your Honor.
What?
Do you think that the president has the power to pardon himself for any past or future crimes he may have committed against the United States of America?
Well, Senator Booker, that would be a legal question. That would be a constitutional question. And so in keeping with my obligation not to give hints, previews, or forecasts of how I would resolve the case, that's not one that I can answer.
Well, I think I agree with you that it is an issue right now. Something I never thought would be an issue before, but it is an issue that our president may intend to pardon himself for future crimes or past crimes. If a president is personally responsible for several $100 million in debt while he's in office, potentially to foreign entities, do you think he has a responsibility to disclose who his lenders are, especially given
case-by-case basis? He was elected and blah, blah, blah.
There's litigation about the emoluments clause. I think it was in the Fourth Circuit. I don't know where it stands, but that clearly is an issue that's being litigated, and one present in courts is not one on which I can offer an opinion.
Thank you. I think it's disturbing that we're having this conversation. I think it's disturbing that we have a president that has brought what should be settled in the minds of most Americans. Presidents should reveal what their debts are, especially if they're to foreign nations. Presidents should not be able to pardon themselves for future crimes. Presidents should condemn white supremacy. Presidents should commit themselves to the peaceful transfer of power. Judge Barrett, you've seen a lot of my colleagues and I put up pictures of people in this room and stories we've told, and I've appreciated the way you've listened. It's not a stretch to understand why a lot of Americans are afraid right now. All we have to do is look at the statements and actions of my Republican colleagues, the Republican Party platform, and the president who nominated you. And even some of your own words, which have been read by my previous colleagues around the Affordable Care Act. President Trump, who nominated you for this vacancy, has not only explicitly stated that the Supreme Court should overturn the Affordable Care Act, but he promised that he would nominate a judge who would, quote, do the right thing, unlike Bush's appointee, John Roberts, on Obamacare. The president has tried to do this legislatively. He's tried to do it administratively. He's failed time and time again, but he's promised over and over again to tear down the Affordable Care Act. Meanwhile, all of my Republican colleagues on this committee, except for one, has voted to overturn the Affordable Care Act because House and Senate Republicans have tried to do it 70 times. The one Republican who did not was an attorney general who joined 20 state attorney generals who sued to overturn the Affordable Care Act. You yourself said, and now I will quote you, that Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. The same Chief Justice Roberts that Trump implied didn't do the right thing. And so, Judge Barrett, you have said that if you were on the court, you will hear and consider the arguments from both sides. I was actually very interested when you said that you would put your family members in the shoes of litigants on both sides. Given all that you've heard said over and over again about the intentions to tear away the Affordable Care Act, to end the Affordable Care Act, given what you've heard about the people who rely on it, given the commitment, that President Trump's said explicitly to only appoint judges who would overturn the ACA, is it unreasonable for people to fear, putting yourself in the shoes of people, is it unreasonable for the people that have been up here as in their pictures, is it unreasonable for them to fear that the ACA would be overturned if you are confirmed to the court?
Assuming what he said is true, that they try to overturn it over and over again, a bunch of people think they rely on it, then of course it's not unreasonable in those circumstances. Jesus Christ.
Well, Senator, I want to stress to you, Senator Booker, as I've stressed to some of your colleagues today, that I am my own person. I'm independent under Article 3, and, I don't take orders from the executive branch or the legislative branch.
I understand that. I guess, can I restate my question? Because I don't think you are understanding it. Sure. I'm just asking you as an act of empathy. Can you understand the fears that are exhibited by the people we put up? The two people I put up, Michelle and Merritt, I don't know what their political party is. I don't know if they're going to vote for me. I'm on the ballot. I don't know. I just know that they were people that wanted their voices to be heard because they are afraid right now and what your nomination represents. All I'm asking is, can you empathize with that? Can you understand that?
Senator, I can certainly empathize with people who are struggling. I can empathize with people who lack health care. One of the things that was so striking to me when we went to get our daughter Vivian from the orphanage in Haiti was the lack of access to basic things like antibiotics. And it just made me appreciate the fact that we had access to health care. So I can certainly empathize with all of that. And with respect to the ACA, should I be confirmed, and as I've said, I would consider the issue of recusal a threshold question of law and whether to hear that case. But should I be confirmed and should I sit and hear the case, as I assured you, I would consider all the arguments on both sides. And one of the important issues in that case is whether, even if the mandate has become unconstitutional since it was zeroed out, whether it would be consistent with the will of Congress for the whole act to fall. It's a statutory question, not a constitutional one, or whether the mandate could be severed out and the rest of the act stand. And so the task of every justice who hears this case will be to look at the structure of the statute and look at its text to determine whether it was the will of Congress when they passed the ACA.
And Judge, I apologize, especially after the good behavior that was noted, that we shouldn't be talking over each other.
No, that's okay, Senator.
My time is running quickly.
Sure.
I guess I just, as a guy who looks at justices, I was just asking you to express that you understand the fear that's
understanding for people with less fortunate circumstances.
People who don't know if they are going to be able to afford their health care, who don't know if they will be denied insurance coverage. And I'm going to move on because of the short time, but I was just asking you is, can you understand the fear giving a president that has said that they will put justice on there that will tear down the Affordable Care Act, thus taking away health care from millions of Americans? There is fear in our country right now. But I want to move now to earlier what Senator Durbin and you discussed. They asked about your views on racism and the role of courts in addressing racial justice. I was troubled that you said that racial justice and equality, and I'll quote you, or how to tackle the issue of making it better, those things are policy questions. I think that that's the quote. How to tackle the issue of making it better, the racial injustice. Those things are policy questions and not for the court. The federal government's own data, and this is, I think you and I referenced this in our private conversation, which I appreciate. You said you were familiar with a lot of the data about the discrimination within our criminal justice system. For example, the U.S. Sentencing Commission shows that prosecutors are more, this is the U.S. Sentencing Commission said that prosecutors are more likely to charge black defendants with offenses that carry harsh mandatory minimum sentences than similarly situated whites. Are you familiar with that, the U.S. Sentencing Commission?
I'm not familiar with that particular.
Does that surprise you?
I mean, I don't know, Senator Booker, that seems an odd thing for me to express an opinion out. As you
I'm not asking you, these are facts. These are just facts.
And as you and I am not familiar with that study. As you and I discussed, I am aware that there is evidence and that there have been studies of systemic racism or implicit bias in the justice system. So I am aware of that issue. I was not aware.
You're aware of evidence that there is implicit racial bias?
I am aware that there have been studies showing that implicit bias is present in many contexts, including in the criminal justice system.
Okay. I'm just going to read some of these other statistics because I think they're really important, and this is independent data from the U.S. Sentencing Commission. And black defendants, again, are compared with similarly situated white defendants who are subject to 3-strike sentencing enhancement at a significant higher rate, which on average added 10 years to sentences. You're not familiar with that study?
I'm not familiar with that study.
Do such cases come before the Seventh Circuit?
The 3 strikes cases?
Yes.
Are you talking about the 3 strikes, the Prison Litigation Reform Act cases where they're struck out, or are you talking about?
I'm asking cases in the criminal justice system that relate to racial bias. Do they come before the court?
So certainly we have discrimination cases. Certainly there are 1983 cases or Title VII cases.
I would imagine so. And in your research for those cases, you familiarize yourself with a lot of the data on the discrimination within the system?
That, we familiarize ourselves with the arguments the parties make and the information that they put in the record. And in some cases, I have had parties submit, or it's submitted in the district court technically and then made part of the record.
And so I just want to be clear. Do you believe that there is, in fact, implicit racial bias in the criminal justice system?
Well,
Which is just a yes or no question. Do you believe?
To what scale isn't exactly known, but yes,
bias in the criminal justice system?
it exists
Senator, it'd be hard
in
to
places.
imagine a system, a criminal justice system as big as ours, not having any implicit bias in it.
So is that
There you go.
yes?
Senator, yes, I think that in our large criminal justice system, it would be inconceivable that there wasn't some implicit bias.
Okay. Over the last
That's
2
a good
years,
answer.
121 of President Trump's judicial nominees to the federal court have said unequivocally that there is implicit racial bias within the justice system, quite clearly. I'd like to turn to.
Shocking, no, because if you understand people and psychology enough, it's like she said, large system, bunch of people, some bad eggs, some, strenuous shit and psychology. Like, she gave a good answer, a very concise answer.
To an opinion you wrote last year about race discrimination, Smith versus Illinois Department of Transportation. The case involved an African-American traffic patrol officer who had been fired from the Illinois Department of Transportation. This employee claimed that he had been subjected to hostile work environment and that the supervisor called him the N-word. But you ruled that the employee had failed to make the case that he had been fired in retaliation for his complaints about race discrimination. And now you acknowledged that, quote, and I'm going to quote you now, the N-word is an egregious racial epithet, but you went on to insist that the employee couldn't, quote, win simply by proving that the N-word was uttered at them. and that he failed to show that his supervisor's use of the N-word against him, quote, altered the conditions of his employment and created a hostile or abusive working environment. And you said that even based on his own subjective experience, this black employee had, quote, no evidence that his supervisors were lashing out at him because he was black. I'm very surprised to have to make this point at all, but even a staunch conservative like Justice Kavanaugh, in my questioning of him, spoke to the obvious harm.
Some people use insults not as a racial thing, but just as an insult in general. Like when I'm playing video games and I say faggot. Doesn't mean anything to do with being gay, homosexual, anything like that. No, it's just, fuck you. But goddamn.
Harm here in a way that you don't seem to. He wrote in a Court of Appeals case that, quote, being called the N-word by a supervisor suffices by itself to establish a racially hostile work environment. And you disagreed with that. Why do you believe?
I'm not saying people should be saying faggot, and I probably shouldn't be, but whatever, I made my point.
That the law recognizes the harm that is inflicted on a black person in this country when they are called that word by their work supervisor, or by anyone really for that matter, and all the history dredged up in that word, centuries of harm. Why do you believe differently than Justice Kavanaugh?
Well, Senator Booker, that opinion does not take a position different than Justice Kavanaugh. It expressly and was written very carefully to leave open the possibility that one use of that word would be sufficient to make out a hostile work environment claim. The problem was that in that case, the evidence that the plaintiff had relied on to establish the hostile work environment involved other, he was driving the wrong way down a ramp and then expletives were used, not the N-word. And the N-word was used after his termination had already begun. And he didn't argue under clear Supreme Court precedent. I didn't make up the objective-subjective element. Under clear Supreme Court precedent, both are required. And he didn't say that it altered the terms of, that's not how he pled or made his case. And it was a unanimous panel decision.
And forgive me if I'm reading this case wrong, but you're saying to me he was not claiming that he had a hostile work environment, and that it is in the fact pattern that this supervisor called him the N-word, and that does not constitute a hostile work environment in the way that Justice Kavanaugh said clearly that it does?
No, Senator, I think you're mischaracterizing what I said, with all respect. In that opinion, the evidence that he introduced to show the hostile work environment was the use of expletives when he drove the wrong way down. He was hired to be a safety driver for the Illinois Department of Transportation, and he based his hostile work environment claim on the use of expletives at him based on poor work performance. That was what he relied upon, and then his termination proceedings had begun. He didn't tie the use of the N-word into the evidence that he introduced for his hostile work environment claim.
Based on that job description and the performance mentioned of driving the wrong way, it sounds like he would have been fired either way. And nothing else would have fucking mattered.
And so as a panel, we were constrained to decide based on the case the plaintiff had presented before us. So the panel very carefully wrote the opinion to make clear that it was possible for one use of the N-word to be enough to establish a hostile work environment claim if it were pled that way.
I'm going to turn to the AutoZone case you discussed earlier with Senator Feinstein. The initial panel of 3 judges that examined the case ruled against Kevin Stuckey. You were not a part of that initial panel, but you did have an opportunity to vote on whether to hear the case before the entire court. You had an opportunity to affirm the bedrock principle enshrined in Brown versus Board of Education about separate but equal, really to say that separate is inherently unequal. But you voted no. You didn't think the full court needed to examine this deliberate segregation of employees by race. But the judges on the court.
Some minorities want things where they can be separated by race. Like there's organizations focused on supporting minorities and shit. So there's that.
Disagreed with you In fact, 3 judges explained, we know that, quote, deliberate racial segregation by its very nature has an adverse effect on the people subjected to it. On one of the essential teachings of Brown versus Board of Education, which I know you're familiar with, is that idea of separate being inherently unequal. Why did you think that these separate unequal facilities were lawful, or why didn't you see this as a practice that was worthy of closer scrutiny?
Senator, as I said earlier to Senator Feinstein, I did not make a merits decision on that case, and I wasn't on the initial panel. The calculation of whether to take a case en banc is different than a merits determination. So I wasn't reaching any decision about whether Title VII applied to that situation or not. Federal Rule of Appellate Procedure, I think it's 35 that governs en banc proceedings, sets out standards, and this case didn't create an intra-circuit conflict or an inter-circuit conflict. And so I didn't think it met federal rule of, all my vote means is that I didn't feel like it satisfied the elevated high standard for en banc review, not that I thought it was correct. There's a lot of deference to panels in my court.
Right, but I mean, 3 judges disagreed with you, and these were judges appointed by Republican and Democrat presidents. They saw the case about separate and equal really compelling. They thought the issue deserved closer scrutiny, and you had an opportunity to join them, but you didn't. You referred earlier to the problem of implicit racial bias in our system, this idea that despite the color of our skin, people can get a hearing, people can get justice. And this denial, it seems to me that you disagree with the prioritization, at least, of your 3 colleagues.
Senator, 8 of my colleagues chose not to take the case en banc, and the en banc process is a different one than the merits decision-making process. To decide that case on the merits and know whether I would come out the same way, I would have had to participate in it and read the briefs and hear the arguments.
And so the 3 justices were wrong, then you disagree with your colleagues?
The 3 judges who dissented, my 3 colleagues whom I respect very much, thought that it met the standard for en banc review. That's a different question than the merits, and so I did disagree with them about whether to take it en banc. So I was within the group of 8 colleagues that decided that maybe that would be an issue we could take up in the future, but not to disturb the panel decision then. But that's not a merits determination.
Thank you, Your Honor. Thank you. Moving quickly, Judge Barrett, 5 years ago, the Supreme Court ruled that the Constitution protects the rights of same-sex couples to marry. This was a Obergefell case, which has been discussed today. The court declared the Constitution grants LGBTQ Americans equal dignity in the eyes of the law. Hundreds of thousands of couples have built their lives on this decision. I've married some of them myself. On that day 5 years ago, the court fulfilled really that ideal of equal justice under law. And yet now the same-sex marriage is legal. We've seen efforts to try to undermine that decision. Justice Ginsburg wrote about legal rules that would, quote, create 2 kinds of marriage, full marriage and skim milk marriage. I firmly believe that our laws shouldn't allow discrimination against people on the basis of who they are. I have a number of questions on this topic, if I can get through them, but I wanted to offer you a further opportunity to address the issue that I don't think you got to fully address, that my colleague brought up. When you did use the term sexual preference earlier today, rather than sexual orientation, is there a difference, and what is it?
Senator, I really, in using that word, did not mean to imply that I think that, that it's not an immutable characteristic or that it's solely a matter of preference. I honestly did not mean any offense or to make any statement by that.
But by what you just said, you understand about that immutable characteristic. In other words, that one's sexuality is not a preference, it is who they are. Is that what you're saying?
Senator, I'm saying I was not trying to make any comment on it. I fully respect all the rights of the LGBT community. Obergefell is an important precedent of the court. I reject any kind of discrimination on any sort of basis.
So you say Obergefell is the decision. Well, what about your 2 colleagues, excuse me, forgive me. What about Alito and Thomas, who have said that the court has created a problem that only it can fix? They clearly don't see that as a precedent worth following. You just said Obergefell is a precedent.
I said Obergefell, of course, Obergefell is a precedent. It is an important precedent. As you pointed out, there are reliance interests now on Obergefell as to why Justices Alito and Thomas have called for its overruling in the recent opinion that they issued. I can't really speak to.
They call it a problem. Do you know what they're referring to?
Well, Senator Booker, I don't know what Justices Thomas and Alito were thinking. That you'd have to ask them.
So we're now seeing cases where gay and lesbian Americans are being denied equal access to Social Security survivors' benefits. One same-sex couple in Arizona was together for 43 years, got married, but one of them died 6 months later, and now the surviving spouse is being denied benefits because they weren't married long enough after 43 years together in love. Does this violate the rule of equal treatment that the Supreme Court has laid down?
Well, in Obergefell, could you repeat the facts of this?
How does that compare to same-sex couples under the same situation? I guess you could try to argue they would have gotten married sooner.
They were together for 43 years. The law changed and allowed them to marry. They married. One died soon after, and they're being denied survivor benefits because they weren't married long enough because the law wrongfully denied them that equality.
So that would be a legal question that would have to come up and be decided in the context of a real case. I mean, it's plain that Obergefell recognizes the full right of same-sex couples to marry, but the question of what are the implications of that for benefits would be something that would come up with before a court later.
But there are some precedents. Maybe I can ask a different
Sure.
question. Can a hairdresser refuse to serve an interracial couple's wedding because they disapprove of interracial marriages?
Well, Loving versus Virginia follows directly from Brown, and it makes unconstitutional any attempt to prohibit or forbid interracial marriage.
Could they refuse to serve a black couple's wedding?
Could a baker or a florist refuse to? Title VII prohibits any sort of discrimination on the basis of race by places of public accommodation.
How about an interfaith wedding?
Well, Senator, I feel like you're taking me down a road of hypotheticals that is going to get me into trouble here because, as you know, I can't opine on how cases would be resolved, and I've said that whether they're easy questions or hard questions, I can't do that.
So I'm not the lawyer that you are, but you seem to honor the precedents that are enough to protect discrimination against African Americans, interracial couples, but you stop on saying that unequivocally about people stopping on religious discrimination or against a Muslim couple's wedding or an interfaith
She's stopping because it got repetitive and stupid.
wedding?
Well, Senator, I think, what Title VII says, as I'm sure you know, is Title VII prohibits discrimination on the basis of race, on the basis of sex. All I can do is say, refer to the statute. But of course, as to whether there would be evidence to show or whether any particular encounter between a customer and a florist or a baker violated Title VII, that would be a case that would have to come up, as I discussed with Senator Sass, with real litigants, litigated on a full record. So you're asking a series of hypotheticals.
And so I'm assuming that you will not respond, or for the same reasons you've uttered before, you will not respond about whether a florist can refuse to serve a same-sex couple.
Well, it sounds like you're on your way to talking about Masterpiece Cake Shop and some of the cases that are very hotly contested and winding their way through the courts. And so I want to make sure that I'm not in a position where I'm eliciting any views that would bear on litigation that's very active.
Well, and I guess you maybe can understand if we go back to the question that both I and Senator Hirono asked you about what you said you didn't mean to offend about whether it's a choice or not. These are about, are they immutable characteristics of an individual, like their race? I just want to just close by saying the story of some folks in my home community of New Jersey, Emily, Sonessa, and Jan Moore. They've been together for 51 years. They've raised 3 children. At last count, and I think that that's a good way of putting it, they have 18 grandchildren and 20 great-grandchildren. And you know how families are. Mm-hmm. But for a long time, they had to keep their relationship and their love a secret. Finally, once same-sex marriage became legal, they got married. And thanks to the Supreme Court's decision in Obergefell, they can now enjoy their full rights. Judge Barrett, you're asking the United States Senate to agree to have you replace Justice Ginsburg, which would tilt the balance of the court further to the right. Remember that it was Justice Ginsburg who warned against full marriage for some couples and skim milk marriage for others. Like so many couples in my state of New Jersey and around the country, Emily, Jan are worried about what might happen if the Supreme Court starts to peel back some of their hard-fought rights. They believe that their love should be valued by their government and equally as the love of any other people. And they believe a lot of the rights that they now enjoy, which were denied in the past to African Americans even, to interracial couples, they believe that they should be able to preserve them. And so my time's expired. You've been very generous, and as has the chairman, in allowing me to go over. I'm grateful to have the opportunity to talk with you more tomorrow.
Mr. Chairman, I have a letter here in support of Judge Barrett, signed by 281 graduates and former classmates of hers at the extraordinary St. Mary's Dominican High School in New Orleans. And I'd like to offer that into the record.
Without objection.
You tired, Judge?
I'm looking forward to the end of the hearing today, I must admit.
Me too. I'm still going to ask you questions.
I was hoping you'd say you were going to yield your time, Senator.
No, ma'am. A lot of my colleagues, and you as well, have talked about the oath that you will take if you're confirmed and sworn in as an Associate Justice of the United States Supreme Court. What's in that oath? What's it say?
Well, that oath requires a judge, I've taken the oath as a judge, to do equal justice to all, without fear or favor, regardless of wealth. To fairly apply the law is what it boils down to not give preferential treatment or express bias in plain terms.
It says you'll administer the law in an impartial manner without regard to your personal feelings, doesn't it?
Yes, it does, Senator.
It says you will support and defend the Constitution, doesn't it? Mm-hmm. Pretty serious oath, isn't it?
It is.
Are you going to take that oath and affirm it if you're confirmed?
Yes.
You're not lying.
I'm not lying. I took that oath before I began as a judge on the Seventh Circuit, and I have not violated that oath, and I would take it again, and oaths are serious to me.
Well, now, Senator Harris just called you a liar. She said that if you take that oath, you'll be lying, that you've already made up your mind on how you're going to vote on some cases, particularly dealing with abortion and the Affordable Care Act. Let's just cut to the chase. She said you're a liar. Are you a liar?
I am not a liar, Senator Kennedy.
All right, I want you to tell me again, look me in the eye, you're in front of God and country. If you take that oath, will you mean it?
I will mean it. If I take that oath, I will mean it.
You swear to God?
I swear to God. And I have sworn at the Seventh Circuit, and I meant it there too.
You'll never break that oath?
I will not break that oath.
No matter what your personal feelings are?
No matter what my personal feelings.
No matter what your religion is?
No matter what my religion is.
So when Senator Harris and her colleagues say you're a liar, they're wrong.
They are.
All right, let's see. You're 48 years old. You're an honors graduate of Rhodes College, an extraordinary liberal arts school. You're an honors graduate of Notre Dame Law School. You clerked for 2 distinguished federal judges. You've been a chaired law professor. You're a devout Christian. You've raised 7 children. I don't mean
Too
to
damn
wax
many.
too metaphysical here, but
Sure, she has the money for it though.
do you have personal values as a result of this?
I would hope that no one would consider me to be nominated for anything if I had no values.
Do you have personal opinions?
Of course, I have personal opinions.
Do you have principles?
I have principles. It wouldn't be fit for office if I didn't.
Let's suppose that we had a nominee appear before us. It happens to be a man in my hypothetical. And he said, I've been nominated for a federal judgeship, and I finished law school, but I hadn't cracked the law book since law school. since civil procedure. And I don't have any opinions. I don't have any principles. I don't read newspapers. I don't even read the news. I hadn't read a book since law school. I'm like
Then there'd be a
Vito
lot of questions.
in Animal House. I'm just fat, drunk, and stupid. I think the Germans are the ones who bombed Pearl Harbor. I think climate change, I think it didn't cause the Cold War. But I'm your guy, because I don't have any value. I'm a blank slate. And that's what is required, isn't it? For me to be impartial? Do you think we ought to confirm that gentleman?
Well,
Impartially do your job, not be a completely impartial, unfeeling person.
then Chief Justice Rehnquist wrote an opinion on this issue and addressing recusal, and he said basically that if someone reached middle years, which one is basically middle-aged if one would be a justice on the Supreme Court, and had a mind that was a blank slate and had no opinions, then one would question such a person's fitness for office.
Well, my colleagues seem to think you're only qualified if you're dumb, if you have a blank slate, if you've never thought about the world. You've thought about the world, haven't you?
I indeed have.
Have you thought about the social problems facing our world?
I have thought about social problems facing our world.
Economic problems?
Sure.
I don't want to know what your feelings are, but have you thought about the merits and or lack thereof of nuclear energy?
No, I really haven't.
How about
delved
affirmative
deeper into
action?
that one.
Have you thought about that just as a
Sure.
subject?
Yeah,
Yeah.
I've thought about it.
How about climate change? I mentioned climate change. Have you read about that?
I've read about climate change.
And you have some opinions on climate change that you've thought about?
I've heard the term affirmative action plenty of times before, but needed to know the exact legal definition.
You know, I'm certainly not a scientist.
I'm not saying you are.
I mean, I've read things about climate change. I would not say that I have firm views on it.
How about, have you thought about the merits of a flat versus progressive income tax?
I have thought fleetingly about that.
Yeah.
These aren't things that I'm not a tax lawyer or an
I'm not trying
economist.
to trap you.
Sure.
How about Justice Kagan? I've always been impressed with her credentials. Graduate of Princeton, did an MPhil at Oxford. I think she went to Harvard Law, was dean of Harvard Law School. You think she's thought about the world?
I'm sure she has, and I too am very impressed with Justice Kagan.
Yeah, me too. You think she's thought about climate change and has personal feelings?
I don't know. I mean, probably, but I can't really say what, Justice Kagan has thought or not about.
Okay. Now, you have personal feelings about abortion, don't you?
I do have personal feelings about abortion.
Do you have personal feelings? Have you ever thought about how we deliver health care in this country?
I do, but Senator Kennedy, one of the things about the judicial role that I've repeatedly emphasized in the hearing today is that I've got personal views and personal feelings on a range of matters, just like every human does, and just like every judge or justice on the court does.
Well, that's what I'm getting at. Now, my colleagues say, and Senator Harris said, that even though you have a personal opinion about abortion, that you will violate your oath to put aside those personal feelings and fairly decide abortion cases. Is that true?
That, I gather, was the thrust of what she was saying to me, yes.
Is she right?
No, she's not right.
And let's talk about the Affordable Care Act.
Didn't he just say violate the oath by putting aside your personal opinions when the oath says to fairly and impartially. What?
That you will violate your oath to put aside those personal feelings and fairly decide abortion cases. Is that true?
That was a clusterfuck of a question.
That, I gather, was the thrust of what she was saying to me, yes.
Is she right?
No, she's not right.
And let's talk about the Affordable Care Act. It's going to, California v. Texas. You've thought about the delivery of health care.
Yes,
You got 7 children.
spent a lot of time.
You've probably been to an emergency
Sure.
room.
Yes.
It would make sense if he said, wouldn't put aside your personal views and shit.
You formed opinions about the delivery of health care. Are you going to, should you recuse yourself?
Well, Senator Kennedy, any opinions that I have, everyone has opinions. Any opinions that I have are just not relevant to the resolution of a case.
Right.
Affordable Care Act case or anything else. And a lot of my opinions, are not ones that are expert. For example, in scientific matters or taxing matters. I mean, might have dinner table discussions, but I don't purport to be an expert in any of those fields.
Well, I'm going to hit this on another lick now because this is serious.
Okay?
Some of my colleagues and Senator Harris say you're lying. Are you lying?
I'm not lying.
Are you going to take that oath and abide by it?
Yes, sir.
Will you ever break that oath?
I will not break that oath, Senator Kennedy.
Okay. Now, one of my colleagues, I don't remember which one, said that because President Trump appointed you, or nominated you rather, that if there's a case that happens to go before the United States Supreme Court after you're confirmed dealing with the upcoming election, they ask you to recuse yourself. Remember that question? Mm-hmm. And you said you would go through the process.
Of determining
Right.
the recusal question.
But you didn't commit to recusing yourself until you, in one way or the other. You said you'd go through the process.
I said I would go through the process. I committed to going through the process of determining whether to recuse, but I did not commit to it.
Now, President Trump nominated Judge Kavanaugh, now Justice Kavanaugh, the Supreme Court. Mm-hmm. Did anybody ask him to recuse himself when the president's tax returns were before the court?
I don't know.
Justice Gorsuch was nominated by President Trump and confirmed by the Senate. Did anybody ask him to recuse himself when President Trump's tax returns were before the court?
I don't know if any motions were filed.
Do you know who Paula Jones is?
I do.
Okay. She sued the President of the United States, didn't she?
She sued President Clinton.
Yeah. Clinton v. Jones. Famous case. President Clinton nominated Justice Ginsburg and Justice Breyer to the United States Supreme Court. They heard that case. Did anybody ask the Justice Ginsburg recuse herself because President Clinton nominated her?
I don't know if any motions were
Do you think she should have?
Well, that's not something I would opine on. I'm sure that she discharged her oath to consider the question.
Did any of my colleagues ask that Justice Breyer recuse himself from hearing Clinton v. Jones because President Clinton had appointed him?
I don't think that's come up in the.
Yeah, I don't think so either. All right, I want to finish this housekeeping because I want to talk about the law. I want to give you a chance to respond to something. Some butthead professor at Boston University
Those look like boot camp glasses.
says that because you and your husband have 2 children of color, that you're a white colonist. The implication is that you're a racist and that you use your 2 children as props. Do you use your children as props?
Senator Kennedy, it was the risk of people saying things like that, which would be so hurtful to my family, that when I told Senator Graham this morning that my husband and I had to really weigh the costs of this, it was saying deeply offensive and hurtful things, things that are not only hurtful to me, but are hurtful to my children, who are my children, who we love, and who we brought home and made part of our family, and accusations like that are cruel.
Yeah, they are, aren't they?
Some people do it
How
though.
low can you go? I didn't want to ask that question when your kids were here. I'm sorry I have to go through that. Okay, let's talk about the law. Let's suppose, I'm not going to ask you how you're going to rule on a case.
Okay?
And you couldn't answer anyway. You'd violate the judicial canons of ethics. I don't know what would happen to you, but it'd probably be pretty bad. Because you're a sitting judge. You're on the
I am a
Seventh
sitting
Circuit.
judge.
But let's suppose that a litigant, let's suppose Congress passed a statute making distinctions on the basis of wealth.
Okay?
And somebody filed a lawsuit and said that their argument is that wealth is a suspect classification. How are you going to analyze a case like that? Tell me how you'd analyze it. I just want to know how you think.
Sure. Well, if someone argued that wealth was a suspect classification, I assume you're saying that they're probably making an equal protection claim.
Yep.
So I would go to precedent would be the first source, because the Equal Protection Clause has a rich body of precedent under it that identifies suspect classes. For example, classes drawn on the basis of race are suspect and they get heightened scrutiny. So I would look through Supreme Court precedent to determine whether there was anything relevant to the question of whether wealth was a suspect class or not.
Okay. You're familiar with San Antonio School
Sounds
District v.
reasonable.
Rodriguez?
My mind's getting mushy this many hours into the
I
hearing,
understand.
so you might need to.
Well,
refresh
let
my
me
memory.
put it another way. Wealth's not a suspect classification, is it?
I am not aware of a case saying that wealth would be a suspect
Yeah.
classification.
Well, here's what I don't understand. I've always wondered about this. Okay, remember, this is Congress passing the statute, not some state. So the litigant is not pursuing this under the 14th Amendment. He's pursuing it under the 5th Amendment. And he's making a substantive, he's making an equal protection argument, not substantive due process. That would be a fundamental right. Where does the 5th Amendment mention equal protection?
Well, the Fifth Amendment has a due process clause,
I
but the
know.
Fifth Amendment doesn't, but the.
But the 14th Amendment has a due process clause and an equal protection clause. But the fifth, which applies to the states, but the Fifth Amendment clause, Fifth Amendment to the Constitution has a due process clause, but it doesn't say a word about equal protection.
That's true, but the Supreme Court has interpreted it as applying the Equal Protection Clause as well against the.
How
federal
can they
courts.
do that if the words aren't there?
Well, there was a case,
Through logic and reason. Duh. I mean, what else do I need to add to that?
I believe the case in which the court addressed this was the one that addressed the constitutionality of segregation in the District of Columbia, which is governed by federal law. And the court said the same principle applies. And so essentially the reasoning of Brown applied there.
Okay, I remember that. All right, let's talk about Heller. Senator Crapo talked about it a little bit. I went back and took a look at Heller. Scalia wrote, you know this better than I do, Scalia wrote the majority opinion. I think Stevens wrote the leading dissent. And it was interesting, they both took an originalist approach, and I went back and looked it up. Scalia relied on, tell me what an originalist approach is again. I know there are different strains, but what's your strain?
Sure. You take the Constitution, so in Heller, for example, what Justice Scalia did, and this is an example of originalism, he went back to the time of the ratification of the Second Amendment to figure out whether when that amendment was ratified, whether that right to bear arms was considered to be an individual right or one that was a civic right.
Excuse me for interrupting, but considered by whom?
Considered by the people.
The people.
By the people at the time, not in the minds of the framers, but by
Okay,
the people.
I went back and looked, I'm sorry. to interrupt.
No.
I've had a little coffee. I'm kind of jacked up. I went back and looked.
Why would you? Because I guess you'd go by like, oh, if the people thought it meant this, then it gained support. So maybe look at it that way to. I guess that has some valid merit to it.
Looked it up. Scalia, he relied on, to reach his opinion, he relied on founding era dictionaries, founding era treatises, English laws.
And if you'd say by the people back then, was there a whole bunch of fancy legal speak and that kind of shit back then? Grammar probably wasn't as strong back then. So when you hear the phrase, the right of the people to keep and bear arms shall not be infringed, they're probably like, hell yeah, I want to keep my guns. So that'd be even more of a reason to argue for it and against a bunch of gun control and assault weapons bans and shit.
American colonial laws, British and American historical documents, colonial era state constitutions, post-enactment commentary, all on the Second Amendment. And then here comes Justice Stevens, he's dissenting. He relied on, in his dissent, he relied on linguistic perfection.
From what I understand, in the dissenting comments, that's where you can throw a little bit of personal opinion and that kind of shit in there.
Professors, an 18th century treatise on synonymous words, on a different editor of one of the same colonial era dictionaries on which Scalia relied. So they both went back and looked at history. Here's my question. Since when did justices become historians? Let me put it another way. If this is the way we're going to interpret the Constitution, by looking at history, why do we need you guys? Why don't we just hire professional historians?
Well, so justices and judges interpret laws, and we interpret texts. And if texts are unclear, you have to figure out what their meaning is, right? And so with the Constitution, sometimes that does require delving into history. One point that I think is worth, Justice Scalia would make this point, that the alternative is, let's say you have an amendment like the Second Amendment's right to bear arms. If it's not evident, looking at it, whether it's an individual right or a collective right for the sake of the militia, one approach would be to rely on the moral judgment of the justice, say whether they think it's a good thing or a bad thing for the common good for people to have that individual right. And of course, judges aren't moral philosophers either. So when you're interpreting a text and you need to turn to something, what judges know is words and what judges know is law. And so having them go back and look at the history, those are familiar things to lawyers. And they're things that all justices consider. As I said earlier in the hearing, all justices do consider the history and the original meaning. And that's been true since the beginning of the court itself. Throughout the 19th century, this idea of
I could go on a little bit of down the rabbit hole as far as certain gun laws and shit. How I think they've affected certain factors of the common good and shit. Like certain import ban. Like you can't expect 32 ACPs, 25 autos, that kind of stupid shit that's not really great for self-defense to be imported. Imported guns are typically cheap. Cheap shit is what's available. So guns that aren't usable for self-defense, kind of only good for, murder, assassination style, for the most. But also it's like, people should just be able to, have the freedom and shit. And we also have exceptions for sporting calibers. I'm pretty sure you can import 22 long rifle caliber pistols. Pretty sure Kel-Tec's 22 mag is made in, well, I'm not sure the country, but there's a summary of that rabbit hole.
originalism isn't new. So throughout, do consider the history and the original meaning. And that's been true since the beginning of the court itself. Throughout the 19th century, this idea of originalism isn't new. So throughout the 19th century, throughout the 20th, the court has resorted back and looked to see what the original meaning is. It's just that I would say the difference between those who identify themselves as, originalists and those who just consider it is the amount of weight that they give it. So all judges have to be skilled in doing it to a degree, because everyone agrees that as a matter of law, the original meaning matters.
Tell me what the Ninth Amendment means.
Well, the Ninth Amendment was once famously described by Judge Bork as an inkblot. The Ninth Amendment has not been fleshed out in litigation. I don't think it's an inkblot, just to be clear. But it's not one that there's a whole lot of case law on.
I want to talk to you a little bit about originalism.
Can we just show the this enumeration in the Constitution of certain rights shall not be construed to deny or disparage others something by the people. Retained? The cross on the T's. Okay, this is the text here. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Sounds to me like the order that they're listed in should not bear any significance. That sounds plain as hell to me.
Or at least your strain of originalism, and how it's related to textualism, and how it's different from purposivism. Did I understand you correctly to say that an originalist believes that judges have to follow the original public meaning of the Constitution?
Correct.
The original public meaning.
Public meaning as distinguished from private intentions of those who drafted the document.
Okay. Does this mean, when you say original public meaning, whose meaning? The average person in the community at that time?
Well, we would say informed observers. So
I'm sorry?
I would say informed observers, so those who were familiar with the debates, which is why looking at the state ratifying conventions, debating the Constitution can be a fruitful source.
Is it okay, I know it's not okay to do it exclusively, but is it okay to consider what the drafters thought?
Sure, and, James Madison's notes from the
course.
Constitutional Convention are a source that the court routinely looks to in trying to determine original meaning. It's just that it's not conclusive.
What's the dimension of time? I mean, at what point in time do you look at the original public meaning?
Well, I would
You look when it's appropriate to and, necessary or relevant, which is kind of always when there's any sort of debate about the translation.
say there's some debate about that because, you won't necessarily have all the evidence you need right from 1791, which is when the Bill of Rights, as you know, was ratified. I think looking at the evidence from before that, so we see that in Heller, that Justice Scalia looked at how people understood that right all the time leading up to the ratification of the Second Amendment because it cast light on the language people were speaking at the time and how they would have understood it. So you definitely can look some before.
Okay, excuse me for interrupting,
Yeah,
but my
sure.
clock's running. Okay, is it, if you look at 10 years after the Constitution was adopted, is that okay? How about
Well,
20?
I think all of that can be relevant evidence. I think the farther that you get away from the ratification of the document, then I think the dicier it gets, because we might say that, between 1791 and, 1801, that people had roughly the same understanding, but of course, as time passes, then attitudes can change. So I wouldn't say that there's a firm cutoff, but I think it's clearly the case that the evidence that's closer to the time is the most probative.
Okay, what's the difference between originalism and textualism?
Well, textualism is how we describe a method of interpreting statutes. So it actually, in many respects, is kind of like originalism applied to a statute. So it would say you take statutory text, for the Clean Water Act or, the make up one, the Amy Barrett Act passed today. You look at what the words would have meant to those who read the act at the time and informed observers of the debate.
So you're looking at the ordinary meaning of the words,
You're looking at the ordinary meaning of the words,
the plain meaning of the words.
the plain meaning of the words.
What if they're unclear?
Well, there are a series of canons of interpretation that judges employ to decipher language. They're like linguistic tools. Like sometimes a list means the expression of some things implies the
No,
exclusion of
I'm
others.
familiar with all those. You know them better than I do. But if the statute's unclear, if there is no ordinary meaning, can you look at legislative history?
Generally, I think that legislative history is a less fruitful source because generally when people make arguments about legislative history, they tend to be less about what a word meant and how a statute would apply to a certain circumstance, which is a little bit different.
But if it's ambiguous, you can look at legislative history as a last resort.
You can look at legislative history to determine whether there was a particular understanding of a word or a phrase. But I think it would be, in most cases, inadvisable to look at legislative history to make a determination, and certainly not to treat it as binding about how a statute would apply to a particular set of facts.
Okay, well, how ambiguous? A lot of textualists say if the statute's ambiguous, if it's unclear, then I can consider secondary sources. How ambiguous does it have to be? 51%? 65%? How do you know how ambiguous?
Well, it's not
It
a
has to be.
precise, it's an art, not a science, I would say, Senator Kennedy. You exhaust all the
An art based on science.
canons of interpretation, and that includes even ones that are not the grammatical canons, but are like the avoidance canon. You run through all of those, and then you look at the structure of the statute. And I think deciding when something crosses the threshold and becoming ambiguous so you can consider canons like the rule of lenity or the avoidance canon, that's a very difficult question, and it's part of the debate about the Chevron doctrine.
Okay. You're familiar with the term purposivist?
Yes.
Okay. I think, you correct me now, a purposivist says, look, I look at the statute, even if it's clear, I can still look at secondary sources and try to figure out what problem the legislative body was trying to solve.
That is so, yes. A purposivist would say that to be faithful to Congress would be to be faithful to the purpose of the statute.
Yeah.
And that sometimes the text doesn't align exactly with the purpose, and that in that circumstance, the
Talking about spirit of the law, basically.
judge should go with the purpose rather than the text.
Now, everybody's a textualist now, or an originalist. But really, aren't a lot of our textualists really purposivists? In other words, they go, well, I looked at the language of the statute, it's unclear. So I checked off the originalist, or rather textualist box, and now I can just go look at what problem Congress is trying to decide and do whatever the hell I want to do.
There has been some academic commentary, definitely in the last 5 or 10 years, saying that that's become kind of the new strain of textualism. You might know the case Holy Trinity.
Yeah.
Yeah, calling it the new.
It's been overruled, though, hasn't it?
Holy Trinity, you mean its approach to statutory interpretation and its
yes.
endorsement?
Yeah.
No, it's never been overruled, but it's fallen out of favor. But this idea of doing what you're saying, stretching to find ambiguity in text, the argument that some make is that it's kind of a new form of Holy Trinity, because rather than saying that the text is clear but inconsistent with the purpose, the argument is that the purpose renders the text unclear.
All right, let me ask you a couple more. I want to talk about a state constitution. In Louisiana, we had a constitutional convention in 1973. We wrote a new state constitution. And we recorded everything. We've got, I think, 14 volumes of transcripts, committee reports, anything you could possibly want to know about the drafting of the 1974 Louisiana Constitution. You're an originalist. Are you telling me to just throw all that stuff out?
No, those things would be the equivalent of looking at James Madison's notes from the Constitutional Convention or the state ratifying conventions. All those things shed light on what Louisianians were thinking when that Constitution was drafted and ratified.
Okay. Mr. Chairman, I want the record to reflect that I landed this plane with 26 seconds left.
So noted. Thank you very much, Senator Kennedy.
I want to just begin by saying,
Hey, it's Willem Dafoe.
perhaps not surprisingly to you, that I was really disappointed by your responses to a number of my colleagues, most recently to Senator Coons, on the issue of whether you would participate in a decision involving the upcoming election if you are confirmed. I continue to believe that if you were to participate in a decision involving that election, it would do enduring explosive damage to the court. I think you know it would be wrong, not because of anything you've done. In fact, I'm not raising the issue of whether you've done any sort of deal or commitment because of what Donald Trump has done and my Republican colleagues, because they have indelibly put at issue your integrity through their statements. The president has said that he's putting you on the court as a ninth justice so you can decide the election. He's been very clear and transparent. And the American people are not dumb. They're watching and they're listening. And if you were to sit on this case, if it goes to the Supreme Court, the American people would lose faith and trust in the court itself. It would be a dagger at the heart of the court and our democracy if this election is decided by the court rather than the American voters. So I wanted to begin by making that point and then go to, again, the real people who are really in this room with us and who will be affected by you as a justice. Yesterday, I introduced you to Connor Kern. You may recall, he's 10 years old. I was with him on his 10th birthday, September 27. He's a remarkable champion. He was diagnosed, as you may remember, with Duchenne muscular dystrophy at age 4. His parents were told to take him home and give him a good life because he would soon lose his ability to walk, told his muscles would get so weak that he'd eventually lose his ability to smile, and still smiling. What lies behind that smile is untold pain, physical pain, the anguish of going through the needles and the prodding and the treatments. But for his family, it's also the anguish of wondering whether they'll be able to pay for treatment that has kept him alive, and whether he will be with them for all of life's milestones. They sent me a letter that they asked me to share with you, saying to you, Judge Barrett, please protect Connor. And they wrote also for millions of other Americans, 135 million Americans, many of them children, just like Connor, but also Christine Miller from Bloomfield, Connecticut. She was diagnosed with a thyroid condition. Her condition was only discovered because of the ACA, which gave her affordable coverage for the first time in a long time using Connecticut's exchange, healthcare exchange. And they wrote for people like Julia Lanzano in Cheshire, Connecticut. She suffered from headaches for years, and she put off going to a doctor because she lacked insurance, so typical and common for people. Put it off. When Julia finally saw a doctor still without insurance, she learned she had a brain tumor, and she was eligible for coverage under Connecticut's Medicaid expansion program, which was created by the Affordable Care Act. In her words, it was a godsend. I raise these stories in part because, as you know, I'm sure, protection for people who suffer from pre-existing conditions is in fact on the line in this case that will come to the Supreme Court only a week after the election. I want to be crystal clear because you stated to Senator Feinstein that, and I'm going to quote, so far as I know, the case next week doesn't present that issue. It's not a challenge to pre-existing conditions coverage or to the extreme lifetime maximum relief from a cap. And technically, you're right, but, it's a big but, if the trial court is upheld and there's no severability, the entire act goes down. That is what the Trump administration is asking the court to do. That's what the plaintiffs want done. Correct?
I gathered that's, Senator Coons had shown the brief with the litigating position
Right.
of the Department of Justice.
I want to move on to another healthcare case. This one involves some of the letters that Senator Hawley was mentioning, and I feel I need to raise them because Senator Hawley asked about them, so did Senator Leahy, and I want to just clarify what they mean. And I want to make absolutely clear, I detest and oppose any religious test. I am not asking you any questions about your religious beliefs.
Okay.
I'm going to be asking some questions about your legal position. So in case I'm unclear in any of my questions, I want you to tell me.
Thank you, Senator.
You signed onto this 2006 open letter sponsored by an organization then known as the St. Joseph's County Right to Life, which was published in the South Bend Tribune. Is that the letter that Senator Hawley was mentioning?
I believe the statement that's on the left, I think Senator Hawley had read the language. I can't remember it verbatim, but it was something like, you know, we support the right to life from fertilization to natural death. Yes.
The letter and ad referred to Roe v. Wade's legacy as quote unquote barbaric, correct?
I don't think that that's part of the statement. I think that's part of the ad that appeared on the page next to it.
They appeared side by side, correct?
I believe that it ran that way in the newspaper. I'm not sure that I ever saw it in the newspaper, but yes, that is my understanding.
That's how it appeared, so they were side by side.
That's based, yes, based on yeah.
And the St. Joseph's County Right to Life sponsored the letter that you signed.
I think the St. Joseph County Right to Life organization was the one who presented the statement that I signed at the back of church.
I want to give you an opportunity to clarify. You didn't disclose that letter when you were nominated to the 7th Circuit in 2017, did you?
I did not, Senator Blumenthal, and I'm actually very glad that you brought that up because I just want to clarify for the record. Number one, that I didn't have any recollection of that letter. I signed it or the statement. I signed it almost 15 years ago, quickly on my way out of church. And, you know, the questionnaire asks me for 30 years worth of material, and I've produced more than 1,800 pages, and so I didn't recall it. After it came to my attention, I did go back and look at the questionnaire, and I actually don't think that particular statement is responsive to question 12, which is, I think, the closest that it would come. I don't think it's responsive, but in any event, it is part of the public, you know, record, and I'm very happy to discuss it. But I
It's part
wasn't
of the
hiding
public
the ball.
record now, and it's a letter. The questionnaire asks for letters. Have you disclosed it now? Have you provided it officially?
So, Senator, as I said, I've supplemented my questionnaire with other material that came to light that I do think was responsive. That one, and I would be happy to answer questions if you wanted questions for the record with more specific detail, but I did not understand that to be responsive to question 12, I think it is.
Well, in fact, we know about it only because The Guardian made it public, I believe. Let me ask you about another letter, 2013 letter. You signed on to this letter regarding Roe v. Wade. It was sponsored by the University Faculty for Life at Notre Dame. You're a member of that organization, correct?
I do.
And the letter described Roe v. Wade as, it's behind me, infamous. And it stated that the signatories, quote, renew our call for the unborn to be protected in law, correct?
Yes, I believe the full statement says, I'm testing my eyesight here, our full support for our university's commitment to the right to life, because, you know, Notre Dame is a Catholic university and embraces the teachings of the Catholic Church on abortion. And so as a faculty member and member of the University Faculty for Life, I signed that statement.
But you didn't disclose that letter.
Again, Senator, I produced 1,800 pages of material, and all 6 prior nominees have had to supplement because they've overlooked things. 30 years worth of material is a lot to try to find and remember.
You disclosed it, in fact, just about 3 days ago, I believe, right?
Because that's when it was brought to my attention. I had no recollection of it, and it surfaced in the press, and so it came to my attention, and then I supplemented. And I did think it was responsive because it was a statement of an organization of which I was part, and I belonged to the University Faculty for Life at the time.
If this process maybe had been a little less rushed, you might have had more time to go back and recall some of these documents?
Well, Senator, as I said, all 6 prior nominees, or the most recent 6, have had to supplement too. So I don't think it really had anything to do with time. I think it has to do with the volume of material.
And when you and I spoke, when you appeared before this committee in connection with your 2017 nomination, I didn't have the benefit of any of these documents, although I asked you about right of privacy and the validity of Roe v. Wade, correct?
Senator, I said on my SJQ when I was nominated to the 7th Circuit, and I said again now, I produced all the material that I could find, and I conducted searches to try to find things that I forgot, and I didn't find that. I understand that someone had to manually go to Notre Dame and look through back archives. I didn't remember it, and I couldn't find it. I assure you I was not trying to hide it from you.
So, Judge, and I apologize for interrupting you. I'm
No,
pressed for
go ahead.
time.
Sure.
Respectfully, I want to share another healthcare story with you. This is about Samantha. One night in January 2017, Samantha went out with a few friends and coworkers. She woke up the next morning in a coworker's home, confused, scared, covered in blood. She'd been raped. After she was raped, Samantha was, in her words, a zombie. She couldn't change clothes, she couldn't shower, she couldn't drink or think. She wanted this event to be erased from her memory. Samantha's attacker also began stalking her, and she was struggling with depression and PTSD. In March, Samantha took a pregnancy test, and then another, then another. They kept coming back with the same result, pregnant. After the horrible violence she faced, she simply couldn't process that she was now pregnant. When Samantha shared her story with me, she said, "I knew if I couldn't end this pregnancy, it would end me." So she decided to get an abortion. Now, as you know, Judge, the landmark Roe v. Wade decision gave her that option. It gave women the right to decide for themselves whether and when to have a child. Roe didn't compel Samantha to get an abortion. It didn't tell her what she had to do, but it gave her that choice. The question that I would like to ask you
Argue for life all you want. I'm not going to argue against that.
concerns your legal position. Does the Constitution protect Samantha's right to have an abortion?
Roe versus Wade clearly held that the Constitution protected a woman's right to terminate a pregnancy. Casey upheld that central holding and spelled out in greater detail the tests that the court uses to consider the legality of abortion regulations.
Now, I'm asking you this question because the group that sponsored the first letter, St. Joseph's County Right to Life, as it was then known, states, quote, "Abortion is never the right answer, even in cases of sexual assault or where the pregnant woman's life is in danger."
If you're on some moral high ground bullshit.
And the purpose of the letters that you signed seem to be a statement of legal position, but you're saying that there is a constitutional right to an abortion.
Senator, the statement that I signed from the St. Joseph County Right to Life didn't say anything about rape or incest or any of those things. It simply validated the teaching of my church on the sacredness of life from conception to natural death.
What I hear you saying is, in the Constitution, there is that right.
You mean when I was talking about Roe and Casey a moment ago?
Well, Roe was correctly decided. You're agreeing that
What I said was that Roe held that the Constitution protects a woman's right to terminate a pregnancy, that Casey reaffirmed that holding, and indeed, many cases after Casey have affirmed that holding again, Whole Women's Health, for example. So I I think we might be talking past each other because the statements that I signed were statements of my personal beliefs and not.
Not your personal belief, Your Honor, your legal position. Are you willing to say that Roe was correctly decided? Because that's really the essence of the question here.
Well, Senator, as I've said, to others of your colleagues in response to questioning, that it's inconsistent with the duties of a sitting judge, and therefore has been the practice of every nominee that sat in this seat before me to take positions on cases that the court has decided in the past.
Well, I think Samantha and a lot of rape survivors would be really deeply fearful about that answer because it provides no reassurance that you believe that Roe was correctly decided. Let me talk about Tracy. I want to tell you about her because she, again, came to me, told me she was diagnosed with stage 4 endometriosis and that it had caused an ongoing inability to have a healthy pregnancy. But as she said, she was one of the, quote, lucky ones. She had access to care and was able to receive treatment to assist in getting and staying pregnant. And I have encountered, maybe you have, many members of the military, veterans, who have sought similar kinds of treatment, and some of them because they've suffered wounds of war. Tracy was scared when she saw the executive director of the St. Joseph County Right to Life recently stated, and I quote, "We would be supportive of criminalizing the discarding of frozen embryos or selective reduction through the IVF process." So Tracy wanted me to ask you, in fact, she asked me to pose this question, is it your legal position that making IVF a crime would be constitutional?
Well, Senator, the statement that I signed, as we discussed, affirmed the belief of my church with respect to matters of life.
I'm not asking about what you signed. I'm asking about your present legal position.
But what I was,
Is making IVF a crime
Senator,
constitutional? Sorry, go ahead.
sorry, I was trying to answer. But you're quoting positions from the St. Joseph County Right to Life. I'm not a member of that organization, and so I'm not responsible for statements that they make. The statement that I signed said what you and I have discussed, and it said nothing further than that. And as for, what policy position someone might take, as I've said to your colleagues, it's not up to me to be in the business of expressing views, and I am happy to talk about views that I expressed when I was a private citizen, but now I'm a judge, and so I cannot publicly express views.
Just to be absolutely clear, I'm not asking about the St. Joseph County Right to Life or their positions, and I understand you may or may not disagree or agree with them, but your legal position, IVF treatment, and I'm not going to ask again, just this last time, criminalizing it,
Well,
would it be constitutional? I think there's a clear answer.
but Senator, I've repeatedly said, as has every other nominee who sat in this seat, that we can't answer questions in the abstract.
I think you can say, I don't currently see any reason why that would be reasonable to make illegal. And I assume they're talking about in vitro fertilization. I don't know what the in vitro exactly means, but I know it just means getting pregnant without having sex, basically. Simple layman's way to put it.
That would have to be decided in the course of the judicial process. With a case, some legislature would actually have to do that, and then litigants would have to come to court. There would have to be briefs and arguments and consultation with colleagues and opinion writing and consideration of precedent. So an off-the-cuff reaction to that would just circumvent the judicial process.
Well, again, I'm disappointed. I think Tracy would find
You
that
could answer it the way I
response
said.
somewhat chilling.
That would be a very legal and professional way to answer it. Not aware of any legal precedent around that and blah, blah, blah. What I've just fucking said already.
Because she and thousands, maybe millions of women, potential parents, would be horrified to think that IVF treatment could be made criminal. And I understand you're not answering the question, but I think she would be deeply fearful. Do you think that it would be constitutional to make it a crime for doctors or healthcare providers to provide that care or abortion care?
Well, Senator, again, that's a hypothetical question. And so, as I've said,
Boo.
I give off-the-cuff responses about abstract issues. And I should clarify to say, it really doesn't matter if they're hard questions or easy questions. It's just any questions that call for an abstract legal opinion are not ones that are appropriate for me to give either as a sitting judge or as a nominee. Those questions in my judicial role can be answered only through the judicial process.
Just to be absolutely clear, there are millions of women like Samantha and Tracy and the veterans I mentioned who are terrified to think that their doctors and healthcare providers would be potentially in jail at risk of prosecution. Doctors who are exercising currently protected rights that Samantha says saved her life. And I believe our healthcare providers are heroes, particularly during the pandemic. But I want to ask you one more question about these documents. In the 2013 letter that you signed, there is the following statement. We renew our call for the unborn to be protected in law, and welcomed in life. What does it mean for, quote, the unborn to be protected in law? Does that statement mean there is no valid constitutional protection for an abortion and therefore Roe v. Wade should be overturned?
You know, I think that statement is an affirmation of life. You know, it points out that we express our love and support for the mothers who bear them. Again, it was a statement validating the position of the Catholic University at which I worked in support for life and to, you know, support women in crisis pregnancies, to support babies. So it's really no more than the expression of a pro-life view.
I expect we'll be talking more about this issue tomorrow. I want to move now to another topic. You and Senator Durbin and others talked about your dissent in Cantor v. Barr, and I think your approach here, in effect, usurps the legislature's appropriate role in making policy judgments. In the case of Cantor, which, by the way, you put first on the list of decisions that you thought were most important that you have written, is that correct?
I don't remember the order in which I listed them.
It was first.
I accept that. I just don't remember the order.
Okay.
I did list it. I remember listing it. But.
Okay. But that decision seems to usurp the legislature's role in deciding who should be permitted to have firearms and who should not, because you decided the legislation.
Let's back up a
accept
minute.
that. I just don't remember the order.
Okay.
I did list it. I remember listing it. But.
Okay. But that decision seems to usurp the legislature's role in deciding who should be permitted to have firearms and who should not, because
Did
you
I miss
decided
something?
the legislature of policy. I think your approach here, in effect, usurps the legislature's appropriate role in making policy judgments. In the case of Cantor, which, by the way, you put first on the list.
It's really no more
Fuck
than
did
the
I miss?
expression of a pro-life view.
I expect we'll be talking more about this issue tomorrow. I want to move now to Another topic, you and Senator Durbin and others talked about your dissent in Cantor v. Barr, and I think your approach here, in effect, usurps the legislature's appropriate role in making policy judgments. In the case of Cantor, which, by the way, you put first on the list of decisions that you thought were most important that you have written, is that correct?
I don't remember the order in which I listed them.
It was first.
I accept that. I just don't remember the order.
Okay.
I did list it. I remember listing it. But.
Okay. But that decision seems to usurp the legislature's role in deciding who should be permitted to have firearms and who should not. Because you decided the legislature was wrong to classify felons as not deserving of firearms. You decided as a matter of policy that when they were not dangerous, they should have that right. That's a policy or legislative judgment. And I think it has huge ramifications for real people.
Yeah, and some of those ramifications
And I
would
wanna
be
tell you
positive.
about one of them from Sandy Hook, Connecticut. Natalie who is shown here with her brother Daniel.
Let me guess, some of them died.
Daniel was killed at Sandy Hook Elementary School in Newtown, Connecticut on December 14th, 2012. Daniel was 7. I was there that day. I saw the parents after they'd learned that they had lost 20 beautiful children. And 6 great educators died as well. In the firehouse that day, there was unspeakable grief. And 8 years later, Natalie says that grief remains with her. But
Of course it does.
Natalie, like Newtown, is resilient and strong, and her grief and trauma have spurred hope and action. She and many young people across the country are leading a movement to deal with the epidemic and scourge of gun violence in this country. Sandy Hook was not an isolated instance. There have been 236 other mass shootings in the last decade. In the last 10 years, gun violence has taken more than 354,000 lives in rural communities and urban communities all around the country. And I'm sure in Indiana and South Bend as well. Your opinion in Cantor goes farther than Justice Scalia in Heller. In fact, you characterized it as kind of radical. It is, in effect, an outlier. And it is, in fact, radical.
Did I say it was radical in the opinion?
I think you said, quote, "It sounds kind of radical to say felons can have firearms." That's a direct quote.
Oh, I didn't remember that particular language.
You can,
I'm not, I just don't recall it, but I'm not nitpicking about it.
we can look it up.
That's fine, Senator. I don't think you're making it up, trust me. No, I'll check it and look it up, but I know that's not the thrust of your question.
It sounds kind of radical because it is radical. In fact,
Radical just means not normal. Doesn't mean crazy.
no courts of appeals, except maybe the Seventh Circuit, has adopted this reasoning.
The Third Circuit, I think, has a rule that's,
The Third Circuit, any others?
I don't know that it's
I
come
think,
up
I
in
knew there
others.
was one circuit that did. I wasn't sure which one, but thank you.
My position was consistent with a Third Circuit en banc decision that had already been decided.
And cutting through all of the legalese, and we've had quite a bit of it going back and forth, what this approach does potentially is mean that Connecticut's gun safety provisions, that the people of Newtown, Kristen and Michael Song, on behalf of their son Ethan, who perished because of a gun that was unsafely stored, they championed a measure called
Because a gun that was stolen.
Ethan's Law. Common sense measures that might have prevented the death of Shane Oliver.
Direct the blame at the person who committed crime, not the person who didn't do every little goddamn thing perfectly. It sounded like some political rhetoric to twist shit to go a certain way. No, fuck you. Should you be as responsible as you can and do what you can to keep people from getting your shit? Yeah. Do what you can to keep people from, like that jackass, from getting it. But the jackass is the one who stole the gun. As far as I know, I don't think it was loaned.
Janet Rice's son, who died on October 20th, 2012. Shane was killed when he was 20 years old in Hartford. He died fighting for his life in Hartford Hospital. And measures like the emergency risk protection order that Connecticut now has. 19 states have these laws. They've saved lives. And extreme risk protection order laws, which help minimize risk, might well be struck down under the reasoning of your dissent.
Respectfully, Senator, my dissent would not reach even those issues. My dissent was about the narrow question about whether a felon who had sold fraudulent foot inserts could automatically be disqualified from his Second Amendment rights simply on that basis. It said that guns can be kept out of the hands of the dangerous, and it didn't say anything about other gun safety or background check. Those are all issues that are being litigated across the country and were not at issue in Cantor.
But supplanting the legislator's judgment about when dangerous people should be protected from themselves if they are potential suicides.
Need to limit the fuck out of that. Slippery slope bullshit that you can go fuck yourself on when you start going there.
As Vic Bencomo, a veteran in Iraq, found when his friend was going to take his life, the emergency risk protection order would have been available, deciding what is dangerous, who is dangerous.
Put the effort into things that will keep people from wanting to kill themselves. Next question.
When weapons should be taken away from them. If the courts are going to supplant the judgments of legislatures, if judges are going to legislate from the bench, that's the import of your reasoning in that dissent. It may not have dealt precisely with any of these particular laws, but the reasoning throws into doubt. It raises the risk to many of them. And
I think it would really help these interviews if they would share some personal opinions, just carefully word them like I'm trying to. With some of my commentary, at least.
folks who live in Connecticut are terrified of that prospect, at least
Well,
many
Sandy
who've
Hook
talked
was
to
a
me.
tragedy. So I express the deepest sympathy for those who experienced that loss there and elsewhere. But Cantor, I hope you take some comfort from Cantor being a much narrower decision that doesn't have any effect on those sorts of laws. Thank you, Senator.
Thank you.
Blumenthal.
Thank you, Judge.
Thank you, Mr. Chairman. Judge Barrett, welcome. Congratulations on being nominated. Congratulations on enduring the confirmation proceedings. And I think it is a particularly good thing. We've made it through what I guess you would call the top of the lineup of the questioning. And some of the smartest and frankly most effective questioners on the Democratic side, and I think it speaks volumes that collectively they've had very few questions for you.
And most effective. He's getting back.
And virtually none calling into question
Pointing that out to
your credentials, which are impeccable,
didn't make the cuts.
your record, credentials,
Make the
which
cut.
are impeccable,
Didn't make the cuts.
your record,
I'll make sure I didn't have
and
something else playing.
what I think has been an extraordinary life you've led. So that should be the source of great satisfaction in terms of the scholarly record and judicial record that you've spent a lifetime building. I want to start by asking you a question. Why is the First Amendment's protection of religious liberty, why is that important?
Well, I think it's broadly viewed that the framers protected and ratifiers protected the free exercise of religion because, for reasons that we all know from history of persecuted religious minorities fleeing to the United States, that enshrining that protection, it was one of the Bill of Rights because it was considered so fundamental.
And why does that matter to Americans? What difference does that make in anybody's?
Less about religion specifically and more about just beliefs, just freedom in general, really. At a conceptual core level, really.
Life.
Well, I think all of the Bill of Rights, each and every one of them is important to Americans because we value the Constitution, including religious liberty.
Well, how about the free speech protections of the First Amendment? Why are those important?
So that minority viewpoints can't be squashed, so that it's not just the majority that can speak popular views. You don't really need the First Amendment if what you're saying is something that everybody wants to hear. You need it when people are trying to silence you.
And how about the Second Amendment? Why is the right to keep and bear arms important?
Well, we talked about
Protection.
Heller earlier this morning, and what Heller tells us is that the Second Amendment protects an individual right to bear arms for self-defense.
Well, I think all of those rights, and I agree with you, the entire Bill of Rights is incredibly important to Americans. I also think what is really striking about this hearing today and also yesterday is that Senate Democrats are not defending what I think is really a radical agenda that they have when it comes to the Bill of Rights. And the topics they're discussing today have little bearing to the rights that are really at issue and in jeopardy at the Supreme Court. And so let's take a few minutes to go through them. First of all, we've had some discussion of Roe versus Wade. You have declined to give an opinion on a matter that might be pending before the court. That is, of course, the same answer that every single sitting justice has given when he or she was sitting in the same chair you are. It is mandated by the judicial canons of ethics. Whether one is a nominee of a Democratic president or a Republican president, that has been the answer that has been given to this committee for decades. But I do think it is interesting that our Democratic colleagues, number one, don't discuss what would actually happen if there came a day in which Roe versus Wade were overruled, which is namely that it would not suddenly become the case that abortion was illegal, but rather it would revert to the status of the law as it's been for nearly 200 years of our nation's history, which is that the question of the permissibility of abortion is a question for elected legislatures at the state levels and at the federal level. And it is difficult to dispute that there are a great many jurisdictions, including jurisdictions like California and New York, who, even if Roe versus Wade were no longer the law of the land, their elected legislatures would almost certainly continue unrestricted access to abortion with virtually no limitations. What I find interesting, though, is that our Democratic colleagues do not discuss what is really the radical position of the most liberal justices on the Supreme Court, which is that no restrictions whatsoever are permissible when it comes to abortion. Yesterday, one of the Democratic senators made reference to the case Gonzalez versus Carhart.
Because in cases like the last guy brought up, there are things that would slow your process. And if it was an early cutoff, you'd likely miss it. And then what? Go fuck yourself? Of course, some would say abortion is an option. Sure.
I'm quite familiar with that case, and I represented Texas and a number of other states as a media.
And some would probably make the argument just because, freedom, my choice, shit like that. Then, of course, there's the argument of it's also the choice of another living being, and you shouldn't be making the choice to kill, I guess you could kind of pull some self-defense logic into that, like if giving birth to it could kill you. It's not really the baby's fault, but giving birth to it can kill you. Or even carrying it to term can kill you, like in the case of a midget. Or sorry, is that not the proper term? Because I'm pretty sure little person is apparently not politically correct now either. So I'm just going to say midget. If their child doesn't have the same genetic abnormality to keep them smaller, they could grow too much and kill the mother just by growing to full term. What's the argument for keeping it there? Can't adopt something that's not able to live outside the womb. Somebody going to make fucking test tube baby things so that they can take that shit out, hook up an artificial umbilical cord to keep it alive? Because if you're not going to consider that, then maybe you should go fuck yourself on this hyper-religious no abortions look.
Meeke in that case. That case concerned the constitutionality of the federal ban on partial birth abortion. That was legislation that passed Congress, was signed into law, that made the really gruesome practice of partial birth abortion illegal. Overwhelming majority of Americans believe partial birth abortion should be prohibited, even those who identify as pro-choice. A significant percentage of Americans don't want to see that gruesome practice allowed.
Yeah, often enough, it's just the way it looks. It's like either way, you're killing some. Like some people are against hunting because, you splatter its guts around and it looks gruesome and shit. Most of the deer I've killed died pretty quick. Even one of the first ones I killed where I shot it in the fucking head and its eyeball bulged out and exposed brains and shit. Looks pretty gruesome. Faster and less painful death than shooting it through the lungs.
Supreme Court, by a vote of 5-4 in Carhart versus Gonzalez, upheld the federal ban on partial birth abortion. That means there were 4 justices ready to strike it down, ready to conclude that you can't ban partial birth abortion, that you can't ban late-term abortion. And by the way, other restrictions that are at question include parental consent laws, parental notification laws. None of our Democratic colleagues want to talk about the justices they want to see on the court would strike down every single reasonable restriction on unlimited abortion on demand that the vast majority of Americans support. How about free speech? Well, we've heard quite a bit about free speech. The senator from Rhode Island just gave a long presentation, complete with lots of charts. I'll say a couple of things on free speech. First of all, our Democratic colleagues, when they address the issue of so-called dark money and campaign finance contributions, are often deeply, deeply hypocritical and don't address the actual facts that exist. Here are some facts. Of the top 20 organizations spending money for political speech in the year 2016, 14 of them gave virtually all of their money to Democrats, and another 3 split their money evenly. So only 3 of the top 20 gave money to Republicans. What did that mean in practice? That meant the top 20 super PAC donors contributed $422 million to Democrats and $189 million to Republicans. Those who give these impassioned speeches against dark money don't mention that their side is funded by dark money with a massive differential. The senator from Rhode Island talked about big corporate powers without acknowledging that the contributions from the Fortune 500 in this presidential election overwhelmingly favor Joe Biden and the Democrats, without acknowledging that the contributions from Wall Street in this election overwhelmingly favor Joe Biden and the Democrats. It's an awful lot of rhetoric about power. But it gets even more interesting when you look at Supreme Court nominations. We just heard an attack on the Federalist Society, a group that I've been a member of for over 25 years. I joined as a law student. It's a group that brings conservatives, libertarians, constitutionalists together to have robust discussions about the Constitution and about the law. What's interesting is nowhere in the Senator of Rhode Island's remarks was any reference to a company called Arabella Advisors, which is a for-profit entity that manages nonprofits, including the 1630 Fund and the New Venture Fund. Now, what on earth are those? Those sound like awfully dark and confusing names. Well, according to the Wall Street Journal this Sunday, in the year 2017 and 2018, those entities reported $987.5 million in revenue. That's nearly $1 billion. We heard a lot of thundering indignation at what was described as $250 million of expenditures. In this case, you've got $1 billion. The senator of Rhode Island said that that much money, much of which is dark money that we don't know who contributed it, he asked, what are they getting for it? And by the way, one of the things they're getting for it is a group called Demand Justice, a project of those entities, spent $5 million opposing Justice Brett Kavanaugh and has just launched a 7-figure ad buy opposing your confirmation. So all of the great umbrage about the corporate interests are spending dark money is wildly in conflict with the actual facts that the corporate interests that are spending dark money are funding the Democrats by a factor of 3 to 1 or greater. A fact that doesn't ever seem to be acknowledged. But not only that, what was Citizens United about? You know, it's interesting, most people at home, they've heard about Citizens United. They know it makes Democrats very, very upset. But they don't actually know what the case is about. Citizens United concerned whether or not it was legal to make a movie criticizing a politician. Specifically, Citizens United is a small nonprofit organization based here in D.C. that made a movie that was critical of Hillary Clinton. And the Obama Justice Department took the position that it could punish Citizens United for daring to make a movie critical.
No. No, no, no. No. Was the common public opinion of Hillary being a piece of shit before that movie? Because that'd be a quick way to say, fuck you, people already thought this shit, we made a movie about it, because people would appreciate it.
Critical of a politician. The case went all the way to the U.S. Supreme Court. At the oral argument, there was a moment that was truly chilling. Justice Sam Alito asked the Obama Justice Department, "Is it your position, under your theory of the case, that the federal government can ban books?" And the Obama Justice Department responded, yes. Yes, it is our position that if the books criticize a political candidate, a politician, the federal government can ban books. As far as I'm concerned, that is a terrifying view of the First Amendment. Citizens United was decided 5-4. By a narrow 5-4 majority, the Supreme Court concluded the First Amendment did not allow the federal government to punish you for making a movie critical of a politician. And likewise, that the federal government couldn't ban books. 4 justices dissented. 4 justices were willing to say the federal government can ban books and can ban movies and presumably could ban books as well.
I'm just trying to think of how they could come to that conclusion. Maybe they would try to argue it's like, oh, it doesn't say you're allowed to make money off of it. You say it all you want, but you don't have to be able to sell it. I don't know. Again, it sounds like a slippery slope.
When Hillary Clinton was running for president, she explicitly promised every justice she nominated to the court would pledge to overturn Citizens United. By the way, Hillary Clinton said she would demand of her nominee something you have rightly said that this administration has not demanded of you, which is a commitment on any case as to how you will rule. Democrats have shown no compunction in expecting their nominees to make a promise. Here's how I'm going to vote on a pending case. Judicial ethics be damned. Or how about the Second Amendment? We've heard some reference to the Heller decision. Senator from Connecticut yesterday talked about reasonable gun control and gun safety provisions. Well, that, of course, was not what was at stake in the Heller decision. Number one, majority decision in Heller, Justice Scalia's opinion, acknowledges reasonable provisions, things like prohibitions on felons in possession are permissible. Your opinion in the Cantor decision likewise acknowledged that restrictions preventing dangerous criminals from receiving firearms are entirely consistent and permissible under the Second Amendment. But the issue at Heller was much more fundamental. It was whether the Second Amendment protects an individual right to keep and bear arms at all. The vote in Heller was 5-4. By a vote of 5-4, the majority struck down the District of Columbia's total prohibitions on owning an operative firearm in the District of Columbia. The argument of the 4 dissenters was not what our Democratic colleagues talk about here. It wasn't some reasonable gun control provisions are okay. That was not the argument of the dissenters. That question we can actually have a reasonable debate on. Reasonable minds can differ on what the appropriate line should be, what are reasonable laws there, but that was not what was at issue at Heller. The position of the 4 dissenters was the Second Amendment protects no individual right to keep and bear arms whatsoever, but merely a, quote, collective right of the militia, which is fancy lawyer talk for a non-existent right. But merely a, quote, collective right of the militia, which is fancy lawyer talk for a non-existent right. 4 justices would have ruled that way, 1 vote away. The consequences of the court concluding that there is no individual right under the First Amendment would mean you and I and every American watching this would lose your Second Amendment right. It would mean the federal government, the state government, the city could ban guns entirely, could make it a criminal offense for any one of us to own a firearm. And no individual American would have any judicially cognizable right to challenge that. That is a radical reading of the Constitution. That is effectively erasing the Second Amendment from the Bill of Rights.
Yep.
Hillary Clinton likewise promised in 2016 that every justice she nominated would commit to voting to overturn Heller. They were big on litmus tests. And Joe Biden, although he refuses to answer just about anything about whether or not he's going to pack the court, he did tell the American people the voters don't deserve to know whether he's going to pack the court. Truly a statement of disrespect and contempt for the voters, unusual in our political process. One vote away from the Second Amendment being erased from the Bill of Rights. None of our Democratic colleagues admit that that is their agenda, and yet those are the justices that Democratic presidential nominees are promising they will appoint. Justices who will take away your right to criticize politicians, justices who will allow censorship, justices who will allow movies and books to be banned, justices who will erase the Second Amendment from the Bill of Rights. And how about religious liberty? Religious liberty is an issue near and dear to a great many of us. The right of every American to live according to your faith, according to your conscience, whatever that faith may be. Religious liberty is fundamentally about diversity. It's about respecting diversity, that whatever your faith tradition might be, the government is not going to trample on it. Religious liberty cases over and over again have been decided 5-4. The case of Van Orden versus Perry, a case I litigated, dealt with the Ten Commandments monument that stands on the state capitol grounds. It's been there since 1961 in Texas. An individual plaintiff, an atheist, a homeless man, filed a lawsuit seeking to tear down the Ten Commandments. The case went all the way to the U.S. Supreme Court. It was decided 5-4. 4 justices were willing to say, in effect, send in the bulldozers and tear down that monument because you can't gaze on the image of the Ten Commandments on public land. Another case, the Mojave Desert Veterans Memorial. This is a memorial erected to the men and women who gave their lives in World War I. It's a lone white Latin cross, simple and bare in the middle of the desert. I've been there on Sunrise Rock where it stands. The ACLU filed a lawsuit saying you cannot gaze on the image of a cross on public land, and the ACLU won in the district court. They won in the Ninth Circuit Court of Appeals. The federal courts ordered that Veterans Memorial to be covered up with a burlap sack with a chain on the bottom, and then a plywood box. When the case went to the U.S. Supreme Court, I represented 3 million veterans pro bono for free, defending that Veterans Memorial. We won 5-4, and there were 4 justices prepared to say, tear down the Veterans Memorial, and under the reasoning that they put forth, they were not far away from saying, bring out the chisels and remove the crosses and the stars of David on the tombstones of the men and women that gave their lives at Arlington Cemetery defending this nation. That is a radical view, and we're 1 vote away. That is utterly contrary to the text of the First Amendment, to the understanding of the First Amendment. When we argued the Ten Commandments case in the U.S. Supreme Court, there was more than a little bit of irony. In that, do you know how many times the image of the Ten Commandments appears in the courtroom of the Supreme Court? The answer to that is 43. There are 2 images of the Ten Commandments carved on the wooden doors as you walk out of the courtroom. You will soon be sitting looking at them. There are 40 images of the Ten Commandments on the bronze gates on both sides of the courtroom. And then, Judge Barrett, when you're sitting at the bench above your left shoulder will be a frieze you know well, a frieze carved into the wall of great lawgivers, one of whom is Moses. He is standing there holding the Ten Commandments, the text of which is legible in Hebrew, as he looks down upon the justices, and 4 justices were willing to say, in effect, bring out the sandblasters, because we must remove God from the public square. That is a profound threat to our religious liberty, and I would note that it doesn't just extend to public acknowledgement.
I don't know about a threat to. I guess the idea would be like, why is that one special? It gets to be in the public square versus other religions, and like it's kind of a stupid argument altogether. I'll just go with that.
Acknowledgements. It also extends to religious liberty. The Little Sisters of the Poor, our Catholic convent of nuns who take oaths of poverty, who devote their lives to caring for the sick, caring for the needy, caring for the elderly. And the Obama administration litigated against the Little Sisters of the Poor, seeking to fine them in order to force them to pay for abortion-inducing drugs, among others. It's truly a stunning situation when you have the federal government litigating against nuns. Supreme Court decided the Hobby Lobby case, another case routinely denounced by Senate Democrats. The Hobby Lobby case concluded that the federal government could not permissibly force a Christian business to violate their faith. It reflected the religious liberty traditions of our country, that you can live according to your faith without the government trampling on it. You know what this body did, I'm sorry to say? Senate Democrats introduced legislation to gut the Religious Freedom Restoration Act. Religious Freedom Restoration Act, when it passed this body, passed with an overwhelming bipartisan majority. Senate Democrats
Most people wouldn't care for certain religions being removed from shit. Like, Islam. Muslim, Jesus. Even the phrases that I've heard quoted from the Quran sound like a close representation of shit I've heard quoted from the Bible. Just worded in a way that sounds more inflammatory and more likely to incite violence and riots and shit. Of course, I haven't read the whole thing of either books.
including Chuck Schumer and Joe Biden and Ted Kennedy, all voted for the Religious Freedom Restoration Act. Democratic President Bill Clinton signed the Religious Freedom Restoration Act. And yet, in the wake of the Hobby Lobby decision, this body voted on legislation to just gut the protections for religious liberty. And I'm sorry to say, every single Senate Democrat voted to do so. Not a single one, zero, would defend religious liberty. Joe Biden has already pledged, if he is elected, he plans to initiate again the attack on the Little Sisters of the Poor. You know, it's interesting, folks in the press like to talk about Pope Francis. And on some issues, Pope Francis has been vocal when it comes to the environment, when it comes to issues concerning immigration. The Pope has been vocal on issues that our Democratic colleagues like and agree with. The press is happy to amplify those views. Somehow missing from that amplification is acknowledgement that when the Pope came to the United States in Washington, he went and visited the Little Sisters of the Poor. Here in D.C., he went to their home here in D.C., and the Vatican explained he did so because he wanted to highlight their cause. That the federal government shouldn't be persecuting nuns for living according to their faith. That's what's at stake in these nominations. And you won't hear any of that from the Senate Democrats on this committee. That's why their base is so angry at your nomination, Judge Barrett, because they don't believe you are going to join the radical efforts to erase those fundamental rights from the Bill of Rights. I believe that issue, preserving the Constitution, preserving the Bill of Rights, our fundamental liberties, I believe is the most important issue facing the country in the November elections. And I think for those of us who value those rights, we should take solace in the fact that not a single Democrat is willing even to acknowledge the radical sweep of their agenda, much less defend it. They know it's wildly unpopular, and look, right at the heart of this is a decision many Democrats have made to abandon democracy. You see, most policies like Obamacare, policies like health care, most policies under our constitutional system are meant to be decided by democratically elected legislatures. Why? So they can be accountable to the people. So if the voters disagree, they can throw the bums out. But too many Democrats have decided today that democracy is too complicated. It's too hard to actually convince your fellow Americans of the merits of your position. It's much easier just to give it to the courts. Find 5 lawyers in black robes and let them decree the policy outcome you want, which makes your radical base happy, presumably makes the millions, if not billions, in dark money being spent for Democrats happy, without actually having to justify it to the American people. Judge Barrett, I'm not going to ask you to respond to any of that. But I do want to shift to a different topic, which is a bit more about you personally, your background. Judge Barrett, do you speak any foreign languages?
Once upon a time, I could speak French, but I have fallen woefully out of practice, so please don't ask me to do that right now.
You can be assured of that, because I had 2 years of high school French, and I suspect yours remains much better than mine. How about music? Do you play any instruments?
The piano.
Do you? How long have you played the piano?
Well, I played the piano growing up for 10 years, and now most of my piano playing consists of playing my children's songs for them and supervising their own piano practice. I look forward one day when I have more time to be able to choose some of my own music.
Now, do the kids do piano lessons as well?
The kids do piano lessons. Some of the older ones who are in high school have gotten so busy with sports and those things that they've stopped, but the younger children do.
Our girls are 9 and 12, and they both do piano lessons, and I will say, at least in our household, it is less than voluntary. One of the things Heidi and I found, particularly the last 6 months during COVID, which has been an extraordinary crisis, is just with 2 kids at home, that doing distance learning when schools were shut down was really hard for us with 2 children. For you and your husband, you've got 7 kids. How did y'all manage through the lockdowns and distance learning? What was that like in the Barrett household?
Well, it was a challenging time, as it was for every American. Our oldest daughter, Emma, who's in college, moved home at that point because she's at Notre Dame. It closed. So Emma obviously could manage her own e-learning, and our high school age children, Tess and Vivian, could too. But Jesse and I just tried to take a divide and conquer approach for the younger 4. And yeah, it was quite challenging, I assure you.
One part of your story that I find particularly remarkable and that I admire is the decision you made to adopt 2 children. You and your husband had 5 biological children, and you adopted 2 more. Both of your adopted children are from Haiti. Haiti's a country that has some of the most crushing poverty in the world. My brother-in-law is a missionary in Haiti, and actually Heidi and the girls just got back from Haiti a couple of weeks ago. was curious if you would share with this committee and with the American people what led you and your husband to make the decision to adopt. It's I think, one of the most loving and compassionate decisions any family can make.
When Jesse and I were engaged, we met another couple who had adopted, in this instance, it was a couple who had adopted a child with special needs. And then we also met another couple who had adopted a few children internationally. And we decided at that point, while we were engaged, that at some point in the future, we wanted to do that ourselves. And I guess we had imagined initially that we would have whatever biological kids that we had decided to have and then adopt at the end. But after we had our first daughter, Emma, we thought, well, why wait? So I was expecting Tess when we went and got Vivian. So she and Tess function, we call them our fraternal twins. They're in the same grade. And it really has enriched our family immeasurably. And you know, once we had adopted Vivian, at that point, then we made the decision that we definitely wanted to adopt again. And so several years later, John Peter entered our family.
So your children have been wonderfully well behaved. I think you're an amazing role model for little girls. What advice would you give little girls?
Well, what I'm saying is not designed, my brother now has left, I was just thinking of what my dad told me before the spelling bee about anything boys can do, girls can do better. And since my sons are sitting behind me, I will also say, but boys are great too.
Thank you.
Isn't that the one I watched?
Your Honor, hi.
Senator,
How are you?
I'm good.
Yeah, it must just be from somebody else.
I'm sure that part of that smile is the fact that I'm the second to last Democrat.
Thank you very much, Mr. Chair. Welcome
Proud for the
again,
difference.
Judge.
Whatever.
Since I have the draw to always follow Senator Cruz, I did want to make one thing clear after listening to that for a half hour, that Joe Biden is Catholic and he is a man of faith. And then I want to turn to something else, and that is that we need a reset here, in my mind, for the people at home, a bit of a reality check, that this isn't normal right now. We have to understand that what people are dealing with, that 7.7 million people have gotten this virus, that 214,000 Americans have died. And for people watching at home and wondering what we're all doing in this room right now, and maybe you're home because you lost your job, or maybe you got your kids crawling all over your couch right now. Maybe you're trying to teach your first grader how to do a mute button to go to school. Or maybe you've got a small business that you had to close down or that's struggling. We should be doing something else right now. We shouldn't be doing this. We should be passing coronavirus relief like the House just did, which was a significant bill that would have been a big help. And I think people have to know that right now. And whether you're Democrat, Independent, or Republican. And that's why I started out yesterday by telling people that they need to vote. Number two, some of my colleagues throughout this hearing on the other side have been kind of portraying the job that the judge is before us on as being some kind of ivory tower exercise. I think one of my friends called it, related that you'd be dealing with the dormant commerce clause. Well, I'm sure that might be true, but we also know that this is the highest court in the land, that the decisions of this court have a real impact on people. And I appreciate, a judge, that you said that you didn't want to be a queen. I actually wouldn't mind being a queen around here, if the truth be known. I wouldn't mind doing it, and kind of a benevolent queen and making decisions so we could get things done. But you said you wouldn't let your views influence you and the like, but the truth is the Supreme Court rulings, they rule people's lives. They decide if people can get married. They decide what schools they can go to. They decide if they could even have access to contraception. All of these things matter. So I want to make that clear. And the third reset here that I think we need to have is that this hearing is not normal. It is a sham. It is a rush to put in a justice. The last time that we had a vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election. The last time we lost a justice so close
Could also say he made the decision to slack.
to an election. That's what he did. Today, we are 21 days from the election. People are voting. Millions of people have already cast their ballots. And
Don't forget, most of the people here make a shit ton of money doing what they do.
I go to the words of Senator McConnell. The last time we had a situation in election year, he said, the American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That set the precedent that so many of you have embraced, or at least you did a few years ago, and that is that in an election year, the people choose the president, and then the president nominates the justice.
The vacancy is now, and the elected president is still in office.
So why is this happening? Well, that's a good question. This guy, our president, he is the one that decided to plop a Supreme Court nomination in the middle of an election when people's health care is on the line with a case before the court on November 10th. So let's see what he said about the Supreme Court. Well, one of President Trump's campaign promises in 2015 was that his judicial appointments will do the right thing on Obamacare. You can see it right here. And in fact, Judge, just one day after you were nominated, this is like a few weeks ago, he said also on Twitter that it would be a big win if the Supreme Court strikes down the health law. So, Judge, my first question, do you think we should take the president at his word when he says his nominee will do the right thing and overturn the Affordable Care Act?
Senator Klobuchar, I can't really speak to what the president has said on Twitter. He hasn't said any of that to me. And what I can tell you, as I have told your colleagues earlier today, is that no one has elicited from me any commitment in a case or even brought up a commitment in the case. I'm 100% committed to judicial independence from political pressure. So whatever people's, party platforms may be or campaign promises may be, the reason why judges have life tenure is to insulate them from those pressures. So I take my oath seriously to follow the law. And,
Yep.
I have not pre-committed, nor would I pre-commit to decide a case any particular way.
Okay, and I think this life tenure, this idea that you have, just for everyone out there, a job for life, makes this even more important for us to consider where you might be. And I know you have not said how you would rule on this case that's coming up right after the election, where the president had said it would be a big win if the Supreme Court strikes down the law. But you have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. Is that correct?
Senator Klobuchar, I just want to clarify, is this the constitutional commentary publication that you and I discussed?
Yes,
'Cause
it
I haven't
is.
done that.
Yes,
Okay.
it is, but it's still a
No,
University of Minnesota law. Yes.
Okay, I just wanted to be sure because
Yep,
I hadn't published in the
I
Minnesota
just,
Law Review.
again, did you ask that question? Did you say that he pushed the Affordable Care Act beyond its plausible meaning to save the statute?
One thing I want to clarify is you said that I criticized, Chief Justice Roberts, and I don't attack people, just ideas. So that was
Okay.
just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
Okay, so you didn't agree with his reasoning in the case that upheld the Affordable Care Act?
What I said And was this King versus Burwell or NFIB versus Sebelius?
That was NFIB versus Sebelius.
Sebelius.
I'll get to King versus Burwell in a second.
What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute.
But
I
it was
made no
still the
comment.
reading that Justice Roberts got to. Now, you also criticized, as you pointed out by bringing up King v. Burwell, another case where the court ruled in favor of the health law. This was in a 2015 National Public Radio interview. And you acknowledged that the result of people being able to keep their subsidies under the Affordable Care Act would help millions of Americans. Yet you praised the dissent by Justice Scalia, saying the dissent had, quote, the better of the legal argument. Is that correct?
I did say that, yes.
Okay, so then would you have ruled the same way and voted with Justice Scalia?
Well, Senator Klobuchar, one of the plus sides or the upsides of being an academic is that you can speak for yourself, that a professor professes and can opine, but it's very different than the judicial decision-making process. So it's difficult for me to say how I would have decided that case if I had to go through the whole process of judicial decision-making that I was describing this morning. Now, having been a judge for 3 years, I can say I appreciate greatly the distinctions between academic writing or academic speaking and judicial decision-making, such that a judge might look at an academic and say, easy for you to say, because you're not on a multi-member court, you're not constrained by stare decisis, you don't have real parties in front of you, consulting with litigants, consulting with your clerks.
Yes.
It's just a different process.
I viewed this one so interestingly because you were commenting on the public policy result, which you and my colleagues on the Republican side have said this shouldn't be about public policy, and you said, okay, that's okay, but then you were really clear on your legal outcome in terms of your view of whose side you were on. You were on Scalia's side, and of course, that was a side to not uphold the Affordable Care Act, which would have been kicked millions of people off their health care in effect because they would have lost their subsidies. And I just see this as interesting because of this kind of dichotomy they're trying to make between policy and legal. And my view is that legal decisions affect policy. I mean, I'm looking at people in my state that'll deal with this if the Affordable Care Act is struck down. Elijah from St. Paul, who was born with cerebral palsy. Because of the Affordable Care Act, he is now 16 and is a proud Boy Scout. Casey, whose brother lives in Alexandria, and he has chronic kidney failure, and he needs a transplant. Without the ACA, that'd be that. Or Burnett from the suburbs of St. Paul, whose daughter has multiple sclerosis, depends on benefits under the ACA. Liliana of Fridley, who has a 21-year-old son with autism and needs her children to be able to stay on her insurance until she's 26. Melanie, a senior from Duluth, who's being treated for ovarian cancer and needs access to the Affordable Care Act. So my point is that these are real-world situations. And so I get that you're not saying how you'd rule on these cases. So what does that leave us with here to try to figure out what kind of judge you would be? And I was thinking last night of when I was growing up, we would go up to northern Minnesota, and we didn't have a cabin, but we had friends that did. And we would go on these walks in the woods with my mom, and she loved to show all the tracks on that path, whether they were deer tracks, and she'd have us figure out what they were, or elk, or maybe even a bear. And we would follow these tracks down that path. And you'd always think, is there going to be a deer around the corner that we're going to see? And very rarely was there one. But we would follow the tracks. And so when I look at your record, I just keep following the tracks. That's what I've got to do. And so when I follow the tracks, this is what I see. You consider Justice Scalia one of the most conservative judges in the history of the Supreme Court as your mentor. You criticize the decision written by Justice Roberts upholding the Affordable Care Act. That is, to me, one big track. Even if you didn't consider yourself criticizing him personally, you criticized the reasoning. You then said in another case about the Affordable Care Act that you liked the legal reasoning, that he had the better legal argument, that Justice Scalia had the better legal argument. You have signed your name to a public statement featured in an ad, a paid ad, that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You disagreed with long-standing precedent on gun safety, which said that felons shouldn't be able to get guns, something that was pretty important to me when I had my old job in law enforcement. This is something that Senator Durbin asked you about. You suggested that you agree with the dissent in the marriage equality case, Obergefell, that it wasn't the role of the court to decide that same-sex couples had the right to be married. I think this was in a lecture you gave where you said the dissent's view was that it wasn't for the court to decide. People could lobby in state legislatures. And all this takes me to one point as I follow those tracks down that path. And it takes me to this point where I believe, and I think the American people have to understand, that you would be the polar opposite of Justice Ginsburg. She and Justice Scalia were friends, yes, but she never embraced his legal philosophy. So that is what concerns me. And I want to turn to an area where I think Justice Ginsburg, whose seat we are considering you for, was truly a hero, and that was the area of voting rights. And that was the area of elections. I think that, what did the president say here? He said, September 23rd, 2020, I think this, he means the election, will end up in the Supreme Court. And I think it's very important that we have 9 justices. I don't think how much clearer we can be. And as I said yesterday, I do not for a minute concede that this election is going to end up in the Supreme Court because people are voting in droves as we speak. But that is what is on the mind of the man who nominated you for this job. Then he said, on September 29th of 2020, I think I'm counting on them, he meant the court, to look at the ballots definitely. So I know you said earlier in questions from Senator Leahy that you are not going to commit to whether or not you are going to recuse yourself for any kind of an election case. But I do want to point out that as the president has said these things, and as he has nominated you, that people are voting right now. They are voting, as I said, in droves. Do you know how many states or people are voting right now, Judge? I think one of my colleagues said it.
I don't know.
It's more than 40 states. People are voting right now as we speak. I think something like 9 million votes have been cast. Do you think it is faithful to our democratic principles to fill a Supreme Court vacancy this close to an election when people are still voting?
Senator Klobuchar, I think that is a question for the political branches.
Okay. That's your right to answer in that way. Beyond this immediate election, I want to turn to the Supreme Court's critical role when it comes to the right to vote, this area where Justice Ginsburg was such a champion. Senator Durbin went over your dissent at length in Cantor v. Barr, where you drew a distinction between individual rights and civic rights. And you wrote that historically, felons should be disqualified from exercising certain rights, like the right to vote and to serve on juries. So my question is this next line where you said, these rights belonged only to virtuous citizens. What does that mean?
Senator, I would need to look at the article to clarify, but as I'm sitting here, I don't think I said felons should lose voting rights. I think what I was talking about is that
Could.
14th Amendment, yeah, that
But it wasn't an article, just to be clear, right? This is your dissent.
Oh, sorry, my dissent.
Yeah, I think it's your dissent in Cantor v.
Yes, you're right.
And it says felons could be disqualified from exercising certain rights, like the rights to vote and serve on juries. But apart from that clause, you said these rights belong only to virtuous citizens. That's what I'm trying to understand what that means.
So the argument in the case, those who were challenging Heller and those who were arguing on the side of the government in the Cantor case is that the Second Amendment is a civic right. And that is how the Supreme Court itself framed the debate, as a distinction between civic rights and individual rights, with voting being a civic right. And in literature, in the historical literature, which was at play in that case.
Okay, but how would you define the word virtuous? Because it doesn't appear in the Constitution.
Well,
I'm just
Senator,
trying to know what that means, because we're living at a time where a lot of people are having their voting rights taken away from them. So what's virtuous?
Okay, well, Senator, I want to be clear that that is not, in the opinion, designed to denigrate the right to vote, which is fundamental. The distinction between civic and individual rights is one that's present in the court's decisions, and it has to do with a kind of a jurisprudential view of what rights are. And the virtuous citizenry idea is a historical and jurisprudential one. It certainly does not mean that I think that anybody gets a measure of virtue and whether they're good or not and whether they're allowed to vote. That's not
Okay.
what I said.
Okay, now let me ask you this in a different way, because now let's go to the real world here. So in Justice Ginsburg's dissent in Shelby, where a 5-4 court struck down a key provision of the Voting Rights Act, she described the right to vote as a fundamental right in our democratic system. And I assume you agree with this, because you just said that, let's not get to her dissent. You agree with the concept that it's a fundamental right, because you just...
As I just said, yeah, the court has repeatedly said it was
Okay,
fundamental.
so she also wrote in her dissent that the Constitution uses the words right to vote in 5 separate places, the 14th, 15th, 19th, 24th, and 26th amendments. Each of these amendments, this is still her talking, not me, each of these amendments contains the same broad empowerment of Congress to enact appropriate legislation to enforce the protected right. The implication is unmistakable. Under our constitutional structure, Congress holds the lead rein in making the right to vote equally real for all U.S. citizens. Do you agree with Justice Ginsburg's conclusion that the Constitution clearly empowers Congress to protect the right to vote?
Well, Senator, that would be eliciting an opinion from me on whether the dissent.
Well, if you can make that argument that felons shouldn't have the right to vote taken away, and you look at what this one says, then shouldn't those be equal rights? Equally protected? Because the number doesn't define significance. And even if it did, the Second Amendment is listed higher.
Or the majority was right in Shelby County, and I can't express a view on that, as I've said, because it would be inconsistent with the judicial rule.
And if there's plenty of legal precedents arguing that certain people can have their Second Amendment right taken away, not a very slippery slope to get to having voting rights taken away now, is it? Voting is considered fundamental. If you're willing to be the kind of piece of shit that can't be trusted with a gun, how much can you be trusted to vote for somebody that would direct the country to a better future and not a shitty one? How about that?
Okay, so here's my problem. So you go out of your way in the case that Dick Durbin was discussing to make this distinction between voting rights and gun rights, but now you won't say whether or not you agree with Ginsburg. And so my view is, just based, again, following those tracks on this case, that you are most likely with the majority, but I know you're not going to answer this. But what I do want you to know is this, and this is where it gets interesting because of what Justice Ginsburg predicted in that dissent. According to the Brennan Center, over 20 states, since that case came out, that withdrew, that took away part of the protections from the Voting Rights Act, over 20 states have now made more restrictive voting laws than they did before that case. Doesn't that suggest to you that Justice Ginsburg had the better of the argument when she wrote that throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet? Do you think that that's true? And I mean, it seems to me that the proof is in the pudding. Like basically, this rainstorm that she said would come has come with all these states, including a number of them that my colleagues over there represent, have enacted stricter laws. Has it happened?
Senator Klobuchar, I want to clarify, you said I was answering Senator Durbin's questions about the Second Amendment, but refusing to answer yours. And so I just wanted to clarify that I had written Cantor versus Barr, and so that's why I was talking about it. But since I didn't write Shelby, I can't really talk about it. So anything that I've written about or talked about, I would be happy to answer your questions.
Okay. All right. But again, it just seems to me you are out of your way on that case. And this is a case that is so real for so many people right now. And that while you can say it's a fundamental right, the issue is that this case and the Voting Rights Act are so key. And let me just say why. We're talking about the entire foundation of our democracy here. For centuries, Americans have fought and died to protect the right to vote. And so what matters is not just what you say about its being fundamental, it's what you do. States like South Carolina, Texas, North Carolina, Louisiana, Tennessee have policies that make it harder for people to vote. And it's a real world thing before the Supreme Court. In fact, back in May, when voters in Wisconsin were standing in line in the middle of a pandemic, in homemade masks, in garbage bags, in the middle of a rainstorm, just to exercise their right to vote, 70 of them got COVID because we didn't know enough about it back then, because the president hadn't told us what he knew, and we didn't know enough to protect those voters. So it ends up at the Supreme Court. What did Justice Ginsburg do? When the Republican-appointed majority on the court ruled that voters in Wisconsin could not have more time to get their ballots in during the pandemic, she called them out in her dissent, in her blueprint for the future, and she said the majority opinion boggled the mind. So what boggles my mind? Well, 2 weeks ago, the U.S. Supreme Court reinstated the South Carolina requirement that mail-in ballots must have witness signatures. In the middle of a pandemic, you got to go and get a witness. In Texas, Republicans have argued that the pandemic wasn't a good enough reason to let people under age 65 vote by mail, despite the fact that over 42,000 Americans under 65 have died from COVID. And the governor right now is forcing that state to have only one ballot box per county, including in Harris County, where there are 4.7 million people. And for those of you that thought a judge took care of it a few days ago, he did. But then yesterday, 3 Trump-appointed judges came in and reversed that. So we're back to one ballot box for people to drop their ballots off in a county of 4.7 million people. In Tennessee, Republicans have tried to prevent ballot drop boxes. I know we had the Secretary of State as one of our witnesses at a Rules Committee hearing, and they have argued in court that COVID-19 is not a valid excuse to vote by mail. In North Carolina, the Supreme Court struck down a core component of the Voting Rights Act. What happened? Well, states like North Carolina passed laws that were so egregious to make it harder to vote that the Fourth Circuit struck down their law and noted that it targeted African Americans with almost surgical precision. So that is what the stakes are. And that is why not having Justice Ginsburg on the court right now is so frightening to so many Americans out there. And that is why we are asking you these questions about voting. So let me turn to another election question, gerrymandering. In 2015, Justice Ginsburg wrote the majority opinion in Arizona State Legislature for the Arizona Independent Redistricting Commission, holding that it was constitutional for the people of Arizona to amend the state constitution to establish an independent redistricting commission. Because of this case, and Justice Ginsburg's opinion, many argue now that Arizona has fairer electoral maps. The decision was 5-4. Here's your example. And now Justice Ginsburg and Justice
And it's possible for that to go the other way too and get worse.
Court. My question is this: must state legislatures abide by their own state's constitution when exercising their authority under the Elections Clause?
Senator Klobuchar, that would be eliciting an opinion from me about whether I agreed or disagreed with the result in that case.
Okay,
And
is it
it's shame doing that.
constitutional for voters to amend a state constitution to establish specific processes for elections, like the voters in Arizona did to stop gerrymandering?
Again, you're asking me for a view on that particular case, and Justice Ginsburg herself gave the most famous articulation of the principle that constrains me from doing so, which is no hints, forecasts, or previews. So I can't express a view on precedent or on how I would decide any question that was provoked by the application of that precedent to a later case.
Okay, last week, a contractor from outside of my state of Minnesota started recruiting poll watchers with special forces experience to protect polling locations in my state. This was clear voter intimidation. Similar efforts are going on around the country.
You don't know that.
Solicited by President Trump's false claims of massive voter fraud, something that, by the way, many Republican leaders, including Michael Steele, the former head of the Republican Party, including Tom Ridge, including Governor Kasich, including sitting Senator Romney, have made very clear is not true. So as a result of his claims, people are trying to get poll watchers, special forces people, to go to the polls. Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record after fully engaging precedent, talking to colleagues, writing an opinion. And so I can't answer questions like that.
Okay, well, I'll make it easier. 18 U.S.C. 594 outlaws anyone who intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote. This is a law that has been on the books for decades. Do you think a reasonable person would feel intimidated by the presence of armed civilian groups at the polls?
Senator Klobuchar, that is eliciting, I'm not sure whether to say it's eliciting a legal opinion from me, because the reasonable person standard, as you know, is one common in the law, or just an opinion as a citizen, but it's not something really that's appropriate for me to comment on.
Okay. Here's one that I think is selection of electoral college electors. You know that each state has laws that dictate how electoral college electors are selected. Judge Barrett, in 1932, the Supreme Court in Smiley v. Home, a case involving my state, ruled that the Minnesota State Legislature could not change election rules unilaterally. Do you agree that the unanimous opinion in Smiley v. Home, which has never been questioned by any other Supreme Court case, is settled law?
Well, I'll say two things about that. First of all, I was not aware of that case, so you've taught me something. But secondly, I can't comment on the precedent, give thumbs up or thumbs down in Justice Kagan's words.
Okay, well, why don't we end there with precedent? I think that's a good way to end here. So you wrote in your 2013 Texas Law Review article that you tend to agree with the view that when a justice's best understanding of the Constitution conflicts with Supreme Court precedent or case law, it is, quote, more legitimate for her to follow her preferred view rather than apply the precedent. And I want to run through a few examples. So Brown v. Board of Education, as we know, that holds that the 14th Amendment prohibits states from segregating schools on the basis of race. So is that precedent?
Yes.
That can't be overruled?
Well, that is precedent. And as I think I said in that same article, it's super precedent. People consider it to be on that very small list of things that are so widely established and agreed upon by everyone, calls for its overruling simply don't exist.
Okay, well, you also separately acknowledged that in Planned Parenthood v. Casey, the Supreme Court's controlling opinion talked about the reliance interest on Roe v. Wade, which it treated in that case as super precedent. Is Roe a super precedent?
How would you define super precedent?
I might have thought someday I'd be sitting in that chair. I'm not, I'm up here, so I'm asking you.
Okay, well,
So-
people use super precedent differently.
Okay,
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled, but descriptively, it does mean that it's not a case that everyone has accepted and doesn't call for its overruling. I don't
okay,
think
so here's what's interesting to me. You said that Brown is, and I know my time is running out, is a super precedent. That's something the Supreme Court has not even said, but you have said that. So if you say that, why won't you say that about Roe v. Wade, a case that the court's controlling opinion in that Planned Parenthood v. Casey case has
She explained that
just
there's a lot of debate and argument over that case, but not the other one. Way to waste your last couple minutes.
as a super precedent? That's what I'm trying to figure out.
Well, Senator, I can just give you the same answer that I just did. I'm using a term in that article that is from the scholarly literature. It's actually one that was developed by scholars who are, certainly not conservative scholars, who take a more progressive approach to the Constitution. And again, as Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
Is United States for Virginia military, is that super precedent?
Senator Klobuchar, if you continue to ask questions about super precedents that aren't on the list of the super precedents that I discussed in the article that are well acknowledged in the constitutional law literature, every time you ask the question, I will have to say that I can't grade it.
Okay. Well, I am then left with looking at the tracks of your record and where it leads the American people. And I think it leads us to a place that's going to have severe repercussions for them. Thank you.
Could tell she thought that from her heated demeanor. Seems extremely professional and very competent for the job that she is slated to assume. I'm going to cut it off there. I'm about 3 hours in.